Hey everyone, good morning. Good morning, Letecia. Good morning, Hope. How are you? Good morning, Lip Lock No More. 4-6 Live. Good morning. Welcome, guys. Day 3 of jury testimony. Pretty excited about this. Hopefully we can find, more jurors. Yesterday they found 18 total. We thought it was 22, but it was actually 18. So they didn't unmute whenever they were reading off the numbers of who was dismissed, and so it was kind of up in the air a little bit, but there is a reporter there. Hi, Tammy Clips. Hi, Lynn. Yes, I put the Sonic sticker. I added that for Gannon. So we now have a Sonic sticker for Gannon, because that represents him. I originally was going to use one of the memorial type things that they had put for him, but whenever I thought about it, I don't want to quote unquote monetize his name, right? Because those are purchased stickers that come with your membership or whatever. So I don't want to monetize his image. Like that just didn't feel right to me. So I did change it to Sonic because I feel like Sonic equally represents Ganon. So because he loved Sonic, that was a big part of his enjoyment and things. One thing I did want to tell you guys was that during Josh Tulini's coverage, he did actually state that the psychologist, Dr. Dorothy Lewis, did find Letecia Stauch to be insane at the time of the murder. The findings of Dr. Lewis's report have been unclear until today. He just happened to mention it while he was talking to the jurors. So we were waiting to find out, listening and eagerly waiting to find out if her report was turned in on time or not, and if that was able to be done. And now we know that her report was turned in on the deadline or before the deadline, and that she will be testifying. So this will be her finding. Interesting, interesting. I know, right? How? No way. I know. Um, and so this is after we have to remember she went through what, 5 competency evals. And so we know she is competent, but now Dr. Dorothy Lewis is saying that she was found to be insane at the time of her murder, at the time of Gannon's murder. Sorry. I don't know. I don't know how they can say that, but here's the thing. With a doctor signing her name saying that she was found to be insane, she will show up, she will testify about her findings and saying that she is insane. And then then it's up to the prosecutor to prove that she wasn't. And so the prosecutor normally would have their own psychologist and things like that evaluate and review everything. But the defense team tactfully waited until just a few days before this whole court process starts. So now now the prosecution will have to find people to combat what Dr. Dorothy Lewis is saying with just very, very little time frame. Really, really ridiculous. Tennessee Mountain High is saying psychotic rage. He asked if Gannon was autistic, and they said for the record that he had ADHD, but that there was early concerns that he may have been autistic, but it was never a diagnosed thing. But he was diagnosed with ADHD. Yeah, all the ones that found her sane can disprove it, right? It's just going to be about how exactly Dr. Dorothy Lewis is wording this and what exactly she puts into it whenever it comes right down to it. So let me pull up the court. That way I know that it is up and ready to go. Yesterday, they were about 10 minutes late to starting. We will be reading through the arrest affidavit leading up to court. Let's see. They do already have WebEx pulled up, which is good. So we will just wait until he starts talking and we will switch to that. Yesterday, they didn't even turn WebEx on until several minutes into it. Yeah, you think you should get an extra charge if the child has issues. I agree. Thanks. Yeah, it makes me sick. She knew what she was doing. Hi, Jane Doe. Welcome back. Welcome back. Okay, so let me pull up her arrest affidavit and we will go from where we left off, basically. We read through first couple pages yesterday during lunch break, and we started basically with the murder of Gannon and what took place that afternoon. So just to refresh for those of you guys who were not here, it says the following section will outline the what have investigators have learned Letitia's activity on January 27th of 2020 was. And so it says investigators believe that Gannon was murdered by Letecia Stauch the afternoon hours after approximately 14:14 of January 27th. Now, keep in mind that this arrest affidavit was written prior to Gannon's remains being found, I think. Let me see. Yeah, I'm pretty sure this one was after or prior to his remains being found. Look at the date of it. My goodness. So date filed February 28th of 2020. He was not found until March 17th. And so a lot of their things in here changed at the preliminary hearing. There were small changes that were made to this and what they knew based off of the evidence that was on his actual remains. Yeah, how many did they get through to get one to say insane? Exactly. She is grimy. I agree. Can't believe it's finally happening. Seems like forever. I can only imagine what his family is going through. I know. Hi, Ramblin' Rome. Welcome. Pretty sure it was you're pretty sure it wasn't, yeah, it just wasn't leaked to the public till April. Exactly, because originally it had a gag order on it, and then that woman leaked it to the press, well, leaked it to YouTube, and then they, released the gag order and let it go out to the public anyways, which they were planning to do. That lady just made it happen earlier than it should have, basically. So, like I said, a lot of this some of the things changed once they found his remains, because obviously they knew at that point her method of how she did things and stuff like that. Um, okay, so more specifically in his bedroom, physical evidence recovered from the residence and inside of Gannon's bedroom supports that a violent event occurred in his bedroom, not away from the house, not out in the middle of nowhere, not in the truck, not anywhere but his bedroom. A violent event occurred. And I'm going to tell you guys, once they got his remains, they were able to see exactly how violent the event was. Um, Hold on one second. Let me pull up.
I can't find my guitar.
You can't find your guitar?
No.
Hold on one Okay, so his wounds are, just to give everyone an idea of what we were talking about here. There is no way he walked to the truck after the wounds that he incurred. There's just no way. And so let me find 1 second. I just had it a second ago. Like the screen went down and back up and then it made me lose it. Okay. Says at her preliminary hearing, Gannon's autopsy results were revealed, which include one gunshot wound, a skull fracture, and 18 sharp force injuries. The gunshot wound was in Gannon's lower left jaw area, and a projectile was recovered from his skull. So she had one bullet connect with him. There was three total that she had fired. One connected, skull fracture, and then 18 sharp force injuries. So we're talking she stabbed him 18 times. or tried to stab him. Some of those were defensive wounds as well. Yeah, 10 a.m. jam session, exactly. He's extremely thorough. Does a doctor need to say she was crazy to claim an insanity defense? So they have to have a doctor say that eventually, right? But the way Colorado tries things, they try it simultaneously. So they're trying the insanity defense at the same time as any regular defense would be tried. And so whether or not this doctor came back and she was able to plead insanity and things like that, or had a doctor to back up those claims, it didn't matter. Either way, the same level of burden of proof is is on the prosecution. And the judge was explaining that a little bit yesterday. He said they used to try it as two separate cases, but now they combine it together. Can I fix Cray Cray? What happened to Cray Cray?
I got lost.
Cray Cray got lost.
Mommy.
Oh, I just seen it in the bushes blocked you for a second. Okay, you are unblocked, Cray Cray. I'm so sorry that happened. Dog jumped into the lap. Was it Jax? Jax, no. Okay. So, let me double check that they're not unmuted yet. Where am I at? Okay, so it supports a violent event occurred in his bedroom, which caused bloodshed, including blood splatter on the walls, enough blood loss to stain his mattress, soak through the carpet and the carpet pad, and stain the concrete below his bed. Some of the photographs of this evidence are included below. There was enough blood in his room to say that he was deceased without needing his remains. So keep that in mind. There was enough blood that they know for a fact that he was deceased without ever having his remains. That's why I know he did not walk out to the truck after the violent event happened. The blood in his room was enough that I know she didn't do this events out on the side of the road somewhere. She didn't take him somewhere and kill him and dump him then. No, this happened inside of this home. And I know that the prosecution is going to have to prove that. So, based on the evidence recovered from the residence, Gannon's remains were eventually brought through the house into the garage and likely loaded into the back of Letecia's Volkswagen Tiguan. After cleaning the murder scene, Letecia utilized the Tiguan to transport and dump Gannon's remains on the evening of January 28th. They know the exact day that she disposed of his remains and the time, everything, because of the data from her vehicle. And this will eventually get into that. And that's why I know that she didn't go to that area of Highway 105, South Perry Park Road in Douglas County, Colorado, prior to January 28th, because they would have noted that. And they would have evidence of that she could have done it at an earlier time or that Gannon didn't return home, things like that. This is direct evidence from the prosecution that they are telling us that proves that Gannon was in that house when he was murdered. And so any theories that he didn't come home or that he was dumped prior to coming home that day and things like that, it just doesn't add up or match up with the evidence that is actually available to us already and that we will hear going forward in this trial. So it says the Metro Crime Laboratory determined that the blood discovered in Gannon's bedroom, the Stauch's garage, and a piece of particle board located off of Highway 105 South Perry Park Road all matched his DNA profile. On Monday, January 27th, Gannon Stauch stayed home from school based on text messages from Letecia to Mr. Stauch. Gannon was upset most of Sunday evening with stomach problem. Letecia did tell Gannon's school, Grand Mountain Elementary, that Gannon would be absent on Monday. Investigators were able to verify that Gannon was marked as an excused absence that day. Letecia also told Albert, I'm going to give them all an excuse at work and stay with him. Indeed, Letecia did come up with an excuse and told her employer via text message at 4:37 in the morning that her stepdad was killed after being hit by a car, and she would not be able to come to work today. Can you imagine lying about your stepdad being killed, being hit by a car, so that you could get out of work? Instead of just calling off, we can't just call off sick or say that my kid's sick or whatever. We are calling off and saying that somebody was, killed in a car accident. That they should pretty much be able to easily look at news reports and everything else and disprove. We later find out that Letecia actually was not employed at this time. She had actually been fired or let go on Friday, the week before all of this. Other electronic evidence, such as time and date stamped photographs and videos, were recovered from Letecia's cellular phone that indicate that Gannon was likely still alive during the morning of January 27th, 2020. As displayed in paragraph 54, images below were taken on Letecia's cell phone at or about 8:13 and 8:17 in the morning on January 27th, 2020, showing Gannon asleep in his bed. Right, exactly, Tammy, and she didn't even have the job anyways. Exactly. Um, okay. So other electronic evidence say that he was likely still alive during the morning of January 27th, 2020. Now, remember, she actually bragged about the fact that she took a photo in the truck that morning, that they took a selfie together. And so that's what they mean by dated stamped photographs and videos and things like that, proving that he was alive, because she made it a point to prove he was okay. Because I honestly believe that she had already drugged him and was hoping that he would overdose in that vehicle. That is my honest to God belief, that that was the intended way that she wanted Gannon to die that day, and that she was going to paint it as if he was a drug addict or messing around with drugs in his free time, that's why he was having an upset stomach and all of those things. But that's just my opinion. As displayed in paragraph 54 below, images were taken on Letecia's cell phone at or about 8:13 and 8:17 that morning, January 27th, showing Gannon sleeping in his bed. Of particular note, his Nintendo Switch is visible lying in the photo on the table, or lying in the table next to him on the bed. Mr. Stauch has said that gaming system was of high importance to Gannon. To date, investigators have been unable to locate the Nintendo Switch. It should also be noted that Letecia used her phone the following day, January 28th, at or about 12:57, to conduct a Google search. Can Nintendo find my Switch? Now, I will tell you that when this was written and when it came out, all of Landon's friends and everyone were in the Facebook groups and talking to us via the voice messages and things like that. And they let us know that the Switch actually did get found. But remember, again, this arrest affidavit came out was written prior to Letecia's arrest and prior to Gannon being found. The family found that Switch whenever they were like cleaning up the house and stuff like that, getting ready for Albert to move out. I'm not sure when the dates coincide in between there, but I don't know if they ever made a big deal to investigators that it was found, or if they just let it go. But the Switch was found. Okay, they are here.
I know it's a Wednesday. We're almost halfway through the week. Good morning, ladies and gentlemen. My name is Greg Warner. I'm a district court judge.
We have a juror right here who cannot bear just a second.
Yeah, can you hear me now? Okay, that's better. Sorry, my bad. Okay. Good morning, ladies and gentlemen. My name is Greg Warner. I'm a district court judge for the 4th Judicial District. Before we begin the jury selection process, I do want to introduce some of the people who are in the courtroom and who you may or may not have already met. You've probably already met Mr. Sproul and Mr. Combs, and our court reporter is Becky Lucas. It's her responsibility to make sure that everything that is said in the courtroom is transcribed into what we call a record of the proceedings. Take just a moment here. You doing okay? Can you hear me better? Is that better? Okay. And remember that she's taking down everything that we say as we say it. She can't take down a nod of the head, and uh-huhs and uh-uhs don't get translated very well either. So if you can all speak up when you are asked questions so that she can hear you. That's especially important for all of you people way back there in the nosebleed seats, because it's really hard to hear from that end of the courtroom the most. So I assume that many of you were probably not thrilled when you received your invitation to come join us. But please understand how important you are to our system of justice. I want to thank you for being here, and I think you should know that the United States conducts approximately 90% of the world's jury trials. Many other countries do not trust their citizens enough to make those kinds of decisions and leaves those decisions to be made by some member of the government. However, when our country was formed, the people who formed our country believed that the government should not have that much authority. As a result, they placed in the federal constitution and our state constitution has a similar right to a trial by jury. That trial cannot be secured unless all of us have the obligation to serve when called. In case you're wondering, yes, I have that same obligation. Yes, I've been sitting in the same seats that you're sitting in. I understand that it is a sacrifice for you to be here and put your lives on hold. And I deeply appreciate your participation in this indispensable part of our democratic society. Thomas Jefferson said, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution." I have spoken to hundreds of jurors over the years. They all told me that they were glad that they had served. They said it gave them a better understanding of how our judicial system works and how important all of you are to it. They also had told me that they were glad that they had served and that if given the opportunity, they would do so again. I do want to remind you that you may not use your cell phones or other electronic devices while you are in the courtroom. If you need a moment to fetch those and turn those off, please do so now. In addition, we are identifying you by number in court rather than by name for a couple of reasons. First of all, due to the number of jurors being called, we do not want there to be any confusion regarding who we are referring to at any point in time. There may be more than one Mr. Martinez or more than one Ms. Johnson, and because of that, it's easier for our staff to keep track of you by number. To give you sort of an idea, we've already had 150 jurors through on this case. So, and we anticipate that there's going to be probably about that number going forward, perhaps more. So that's why we're referring to you by number as opposed to name. In addition, while the defendant, the attorneys, their staff, and court personnel will know your name, referring to you by your number is to protect you from contact by the media or other persons, curiosity seekers, and the like, to protect you from unwanted publicity, and to ensure that no outside information is communicated about you through the process and the trial. Finally, after talking with a lot of jurors over the years, they all told me that they are more comfortable when referred to by a number in open court rather than a name. The fact that we are identifying you by number should have no impact at all on the presumption of innocence that the defendant is entitled to, or any impact in any other way as you consider and decide this case if you are selected to serve as a juror in this case. The case we're about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this trial is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are lawyers with the district attorney's office. Would stand and introduce yourselves, please.
Morning. Morning.
I will sometimes refer to the district attorney as the prosecution or the people. The defendant or accused is Letecia Stauch, and she is represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called an information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case? I never did. Go ahead, Steve. Thank you. We've already had this issue a little bit, but I want to ask before I go any further, do any of you have any difficulty either hearing or seeing what's going on in the courtroom? Please raise your hand. All right. Looks, hold on, because I have to call you out by number so that I know who I'm talking with. Okay, so first of all, juror number 31 in the sort of, I'm terrible at colors. It's sort of a salmon colored shirt. Yes, that would be you. I say my house is pink. My wife says it's salmon, and I say it's still pink, but it looks like it's sort of a dark salmon colored shirt there. Is that fair? Okay. Are you able to hear me okay? Okay, and then there was a hand in the back, and that would be juror number 65. Yes, sir. Gray hair, long gray hair and beard. Okay, can you hear me now? Okay, so I just need to make sure that I keep the microphone up, and I will apologize in advance to everybody else. Usually not anybody has difficulty hearing me except my children, but I think that's more by choice because I have a really loud voice, but I'll try and keep it using the microphone. Is this better when I use the microphone? Okay. All right. I'll just have to watch that more closely. In this case, 12 jurors and 6 alternates will be chosen. They will consider all the evidence produced during the trial. The jurors will determine the facts based on this evidence. The attorneys anticipate this case will take 6 weeks for trial. This does not include deliberations or jury selection. We hope to start the presentation of evidence in this case on April 3 of 2023. So that would mean finishing evidence sometime mid to late May. I understand the burden that such a lengthy trial places on people. I previously presided over one case that took about 18 weeks from start to finish. So I get it. I understand the commitment here. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will not be any trial on Thursdays as I have other docket matters that I have to attend to on those days. You will be able to go home to your families each day, and though you will not be able to discuss anything about this case with them, you will be able to talk to them about anything else. You'll be able to go on about your normal daily activities. You just can't discuss anything about this case with anyone. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? Please raise your hand. And we're going to start in sections. So I'm going to start over here first. So let's see. Juror number 5 with the gray hair and a dark shirt. Yes, ma'am. Okay. You actually are juror number 5 because your juror number may have been 1786, but what we're referring to you hereby is your seat number. And before I forget, and before we take any break or get any further, please remember where you are seated, because when we take a break, you got to come back and sit in the same seat. We honor the 3rd grade seating chart here, so it's really important that you be in the same seat. So juror number 5, you had your hand up. What's going on? When is that? Okay. And juror number 7. Yes, ma'am. That's you. Yep.
I have 2 children at home. So
How old are they? And middle schoolers, junior high? Okay. So it sounds like during the large portion of the day, they would be at school. When do they get out of school? And would there be anybody that can pick them up, get them home? Do they take a bus? What do they do?
I'm not a full Spanish teacher.
Okay, so it's, so you have two children that you're the caretaker for, but those are at school during the day. They have activities after school, but you're also a Spanish teacher. Do I have that right? Okay, and juror number 8.
That's about to be placed.
When is that? Uh, Okay. And where is it that you would need to go? And if he's placed into the nursing home, what would be your role in that? Well, the house that he's moving out of, I take it then he must not be living with someone. He's living in his, I got it. Okay. All right. And juror number, oh, I thought 9, number 10. Yes, ma'am.
I'm the physical ability. Therapist has recommended just that I have diagnosed. It's done. I go.
Okay. In the front row here, juror 11. Yes, ma'am.
I am the sole provider for myself financially. If you
What kind of work do you do, ma'am?
service at Lowe's,
Okay. And is that an hourly or a salary? Okay. And juror 12. Yes, ma'am.
my daughter's getting married next week
Congratulations.
in Arizona.
And when exactly is it?
She's getting married Friday, and we weren't coming back to town until this,
Till,
dropping my husband off
got it.
Albuquerque for work.
Anyone else in the front row? Let's see. Juror 15. Yes, ma'am.
Played CPA. Need I say more? It's a month.
This is, there's something coming up soon.
Yeah, it's crazy.
I'll see if I can get the government to change those deadlines.
That would be awesome.
I'm sure they'll be interested in my input. Anyone else in the front row over here? No? Okay. Juror number 3. Yes, sir.
I can't speak too much English, I can understand too a lot.
Okay. And what kind of work do you do, sir? Okay. All right. And then let's see, we were at juror 17. Did you have your hand up, ma'am? No, she's 15. 6. No? Okay. Juror number 18. Yes, ma'am.
I have some health issues
And I cannot guarantee you I would be here every single day.
Okay, can you,
To you, I could sit in the courtroom without having to be excused without waiting for breaks.
well, typically what would happen is that we will have a break in the morning, we'll have a lunch break, we'll have a break in the afternoon. If people need to stand, stretch, those sorts of things, they can do that. Okay,
I did just issues.
okay.
And I have no control.
Okay. Anyone else in the front row? Juror 20?
I am a full-time fifth grade homeroom teacher. Hired subcommittees for the entire school year and also a full-time ninth class.
Let's back up for a moment. As I understand it, you're a full-time fifth grade teacher. And you're going to nursing school or you teach nursing school?
Nine classes, hours.
Okay, is there anybody else that I missed? Juror number 5?
Just issues.
Okay. Okay,
Yours.
5. Right, and then in the, this back section over here, front row, juror number 23. That would be you. Yes, sir. Perfect. When is that? Of April? April 1? Oh, 13th. Okay. Okay. All right. Others in that first row? Let's see, 23, 20, juror 25. Yes, ma'am. Okay. Juror number 26.
I go to school and I have classes on Tuesdays and Thursdays. I have oncology appointments in May.
Tell me about the classes on Tuesdays and Thursdays.
It is, economics. And I have, ethics.
So you have more than one class on Tuesdays? 3 classes, okay. Okay, and juror 27? Yes, ma'am.
I don't feel I could be impartial to this.
Okay, I'm not asking that. I will ask that later. I'm not asking that now.
Appointment on the 24th and surgery on.
Okay, we won't even be starting trial until after that. So,
On for the month of April.
okay. Anything else that you want to tell me?
That's about it. Thank you.
Okay. All right, and in the second row, that would be juror 36. Yes, ma'am. Yep.
Your Honor, I'm in the middle of a, our friend here 3 times a week. So,
Let,
last half of my treatment. That long with it. Not the most comfortable, secondary to that, I'm on support fracture. Been gone for that amount of time. Other 2 things I could probably work. Back and sitting.
okay, so I just wanted to make sure that I understand what you had told me because it sounded, it wasn't clear to me whether you were a patient or whether you were the doctor. You're the patient. Okay. Okay, just wanted to make sure. All right. Also in the second row, nobody else till the end, 41, juror 41.
I own a small business with 4 employees. On call for repair. I'm the only one that can come. Ultimately, receptionist to
Okay. And
vacations. For the
okay, what kind of business is it?
spa salon.
Okay, right. Okay. And back row. Juror 50? Yes, sir. Okay, thank you. Anyone else in that back row? Let's see, 52? Okay. If you need to stand or stretch or anything while we're doing that, or while we're doing this, feel free to do that. It's okay to do that. And will that help? Okay. It's not scheduled yet. You just, okay. All right. Got it. Anyone else in that back row? Let's see. The juror 54. Yes, sir.
Your Honor, loss of wages, I, primary source of income for my wife, so my loss of wages. Got it.
Okay. Anyone else in that row? No. All right. This section here, first row, juror number 28. Yes, sir.
I'm the only, by myself and, family trip and for.
Okay. Next in this row be juror 30.
Thing one, I've got a non-refundable vacation mid-April. Number two, I manage a group of consultants. 12 of them, and months would be devastating.
Okay. Next, juror 31. Yes, sir.
I attend my mother on a daily basis. Her meals ready for the evening. Grocery shop for her. What her other needs are, doctor, dentist appointment. I also
Um, Now, as far as tending your mother, you would still be able to do that. It would just have to be outside of court hours, like before 9 o'clock in the morning, well, before 8:30 in the morning and after 5. Okay,
Ready for an evening meal. Being taken care of. I've got a sister, but they both, one is just had an amputee.
okay. All right. And juror 31, or I'm sorry, juror 32. Yes.
Urinary problem.
Okay. Anyone else in the front row? Second row. Let's see, we'll start over here because it's a little bit easier. Juror 48 on the end there. All right. And juror number 46.
Children, 2 and 3, or I'm sorry, 3 and 5. One's in preschool, half day preschools. Oh, she also has.
Anyone else in that row? Juror 45. And how old is your mother? Anyone else in that second? Juror 44.
Having company. Also,
Anyone else in that row? On the end there, juror 42. Okay. When was the TBI?
Been going on for the past 20 years.
Okay. Okay. All right. Thank you. All right. And in the third row, juror 56 on this end. When are you doing that? Of this month? Okay. Okay. Thank you. Juror 57.
Yes, I'm the sole caregiver for my 84-year-old father. He could be able to transport him to appointments and stuff. During the day and
All right. Anyone else? Let's see. The end. Juror 61. Yes, ma'am.
Our house in Florida, April 11th.
Okay. T- um, tell me that again, because you're okay. Okay. I didn't catch the first part of the date. That was all right. Okay. Juror 62. All right. And then the next row behind that, juror 3. This is going to be the bad part here because now I'm in the area with the gentleman that can't hear me unless I speak into the microphone. Juror 63. Yes, on the end. All right. Juror 64. Juror 65.
Not for sale. I gotta work, but I gotta keep my bill and stuff hanging on the house.
Were there other hands back there? Okay, juror, hold on just a minute. Um, Juror 66. Yes, that would be you.
I don't think that's 66.
It is, and I just noticed that it's juror 67. Right? Juror 68. And juror 69. All right, in the back row. Juror 70. That's on this far end over here. Yes, ma'am. Juror 71. Okay. Juror 72, did you have your hand up? Yes, ma'am. Okay, where do you go to school? Okay, I've already had some UCCS students in through here, so I understand what the situation is. In addition, if it, well, I can provide a letter to you for your professor to let them know. The other thing that I want to ask is, because some of the UCCS students said that they would potentially be able to, I think the classes some of the classes were recorded and they said they could catch up with them after we were done for the day with trial. Is that a possibility? Okay. All right. Juror 73, did you have your hand up, sir? No, the gray-haired gentleman, did you have your hand up, sir? No, okay. Juror 74, did you have your hand up? No. Juror 75. Okay. I need to go through some reasons why a person may be disqualified from jury service. So if any of these reasons apply to you, please raise your hand. Are any of you related to the defendant or any of the attorneys? Please raise your hand. No response. Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or partner in business with, or surety on any bond or obligation for the defendant? Essentially, that's a long lawyer question asking whether or not you have a particular relationship with the defendant. Does she rent from you? Do you rent from her? Do you employ her? Does she employ you? Any of those kinds of things. Anyone think they're in that category? No response. Are you now or have you ever been a party in a civil lawsuit involving the defendant or have complained against or been accused by him, by her in a criminal prosecution? Anyone think they're in that category? No response. Were any of you a witness to any matter related to the crime or its prosecution? Does anyone here think that they are a potential witness in this case? No response. Do any of you have a personal or financial interest in the outcome of this case? No response. Do any of you have any feelings or a bias for or against the defendant or the prosecution? Please raise your hand. Juror 20? Yes, ma'am. Okay. I want to make sure that I heard because you're soft spoken. I had a little bit of a hard time. You teach Gannon Stauch's sibling currently. Okay. And given that, and I don't want you to tell me any specifics. You know what? I think this is just, yeah. Let's just, what I'm going to do is I'm going to excuse you based on the personal contact. And I think that's enough. So we'll just excuse you at this point in time. And juror number 2. Yes, sir.
I think I just have a bias from reading the news over the last couple of years and following the case.
Okay. And I'll get to that in more detail, but I appreciate you bringing it up now because that is going to be a question that I'm going to ask about bias as a result of publicity because this case has received some. So I will be asking those questions separately, but thank you for mentioning it now. Juror number 3, did you have your hand up, sir?
I had an appointment tomorrow in Denver in the hospital.
Okay. So, and I was going to check on you in just a moment to see how you were understanding things that were going on. And you said that you had, how have you been doing in understanding us so far? I'm sorry? Okay. Are any of you an employee of any public law enforcement agency or the public defender's office? Please raise your hand. And I have juror number 22. Yes, sir. What kind of work do you do there? Are you a certified peace officer? But, okay, so you're a civilian, but your paycheck comes from CSPD. Okay. Okay. And is that, I'm just trying to understand the relationship. Is that a full-time spot at CSPD? And the records that you work with, are those arrest records or personnel records or what? Okay. Anyone else? Juror number 9. Yes, sir. For the State Department.
State of Colorado.
Right, right. Yeah, my question was not very artfully phrased. So it's the state of Colorado. Anyone else? All right. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they fit in that category? Response. Please raise your hand if you are unable to read, speak, or understand the English language. And juror number 3, you said that you have some language difficulty. Are you able to read the English language?
You can speak too sometimes.
Okay. Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. Anyone think they're in that category? Let's see, where are we at here? Juror 52? Yes, juror 52. Oh, right. Okay. Yeah. Anything that you've not raised before, juror 42? Anything that you've not raised before? No, 42 is this gentleman over here. You're 42. Yes, that's okay. 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 So, and I thought there were some hands over here. No? Any other hands aside from those two? Juror 25? Well, and if you're selected to serve as a juror here, you won't be able to do that. So my question is, do you have a physical or mental limitation? Okay. Anyone else aside from the people that I've talked with? No. All right. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household, such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're in that category? Please raise your hand if you've served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Anyone think they're in that category? Juror 56. Yes. When did you do that? The beginning of 2022. Okay, all right, thank you. Anyone else? All right, no further response. Council approach, please.
Okay, so we know they're going to be muted while the council is approaching. So there was 18 jurors that were left yesterday. And sorry if I just ear blasted you. I just thought about the fact that everybody has headphones on to hear the jurors. So I'm sorry, guys. There were 18 left at the end of court yesterday, we found out. And the other thing that we
All right,
found
ladies
out,
and gentlemen, what we're going to do is take about, oh, sorry, Beck. Ladies and gentlemen, what we're going to do is take about a 15-minute recess. Here's what you can expect will occur. If I can have everyone back in the hallway, ready to go at 10 after 10. Then what's going to happen is when you come back, there's some jurors that I will excuse. Other jurors will remain here and we will have further instruction and further questioning for those jurors. And we will proceed from 10 after 10 until about noon or so. So at this point in time, I can have all the jurors exit the courtroom and we will see you back at 10 after 10. All rise for the jury, please.
okay, so they're going to dismiss them. Then they'll probably talk for a minute, which we may or may not be able to hear. But before they say that, the other thing that we learned yesterday was while Josh Delaney was questioning people, he actually mentioned that that the Dr. Dorothy Lewis, would in fact be testifying, and that she did in fact find Letecia to be insane at the time of Gannon's murder. And so that was one of the things that he brought up to them with Dr. Lewis finding her insane. You know, would that be something that they would understand, that now that a doctor has said she was insane, it's not his burden to prove that she was insane. It's not her burden to prove that she was insane. It's the prosecution's burden to prove that she wasn't. And so that's going to be huge, I think, because I mean, I don't know. They found this doctor to finally say it. I don't know, Jackie, and we will find out, I'm sure, during trial. But until then, you know, we just have to go with what the doctor says. We can't question that or whatever, because now it's like set in stone that she was proven to be insane during the time of the murder. And she'll come up and she'll testify about how and why she feels that way during this trial. That'll be a big thing. But also, the prosecution will then put counter defense judges, or I'm sorry, my goodness, counter psychologists to counter what the defense is saying. So they'll have psychologists come in and say, no, we evaluated Letecia on this date, and this date, and we didn't think that she was insane. That is very beautiful. Can you color on this side too?
I know it can be.
I thought he was going to start talking. He just told them to be seated. He was talking to the attorneys and such, basically. Yeah, Spudler, it's huge. It's very huge because now this report didn't have to be there until this past Wednesday. So that only gives the prosecution just a few short weeks to find a psychologist who is available to come into the court and counteract whatever it is that the psychologist, Dr. Dorothy Lewis, is saying in her reports, and why they don't believe that Letecia was insane during the time of the murder. And so it's going to be interesting to see how both of the psychologists approach this. Yeah, she's crazy, not insane. That woman is not insane. I know. So it'll be interesting.
Were you, oh, I didn't know if you were wanting to make a record about something as you were standing up
I
there.
was just playing with the fancy light.
Got it, okay. All right.
I didn't spill my coffee.
Good job.
I don't know, Jane Doe, what her technical diagnoses are um, currently, but they are saying that she was insane at the time of the murder. Now, how they can go back and prove what her mind was doing and her brain was doing on January 27th, 28th, 29th, all of those days that this occurred, I don't know how they're going to do that. I'm very intrigued to see actually how this process works. Yeah, Dr. Lewis, I question your credibility. Right, the amount of planning. It's going to be very interesting to see how they prove this. Well, but then again, the burden's not on them to prove that, right? The burden is on the prosecution to prove that she wasn't. And so she's going to have to prove it to a certain point, like what her report says and things like that. But the burden is on the prosecution to prove that everything that she is saying is wrong. And how do you disprove somebody's opinion? That's very difficult to do because somebody's opinion is their own opinion. I don't know. Yeah, I'll be interested to see this.
In the summertime, do you play once a week?
Um, sometimes. Play a lot. I'm not playing a lot right now.
With the one on Temple and Gap.
Um, no. I like playing around with horses.
Or something.
Yeah, he lives right on.
Apparently Judge, our mics are picking up stuff over here today. I just got a text.
Thank you, because they're off. So apparently turning them off is not the issue.
Although, what happened yesterday was working fine.
Yeah. No, they are turned off, so hmm. Yeah, you can put it back on the floor. Oh, you did. Okay. You can put the microphones back on the floor if you want to. And it may be that we just, because we're streaming it the way that we are, that we're just going to have to do it without microphones on the council table and deal with it, just like we used to. But we'll have everybody up front here and the jury, so they ought to be able to hear everything fine. So that ought to be fine.
So we apparently weren't supposed to be hearing their whispering. But I honestly couldn't make out much of what they said. I don't know about you guys because I also was talking. So yeah, she's definitely a murderer. I know for sure what she did and how she went upon it during it. There's no excuse you can give besides you're a cold-blooded murderer, right? He was. He was very sure, strong about his feelings, and I can totally understand where he was coming from. Well, again, everyone pretty sure the prosecutors have some experts on their side, as well as her actions trying to cover it up. Wait, I agree with that. I agree with that. I hate that they gave them such a short time frame. You know, that was very tactical, I think, by the defense to give her such a limited time. She is still a danger, right? However she wants to put it, she is still a danger. I agree with that. I think the overkill, the multiple uses of weapons at different times, she could prove she wasn't insane when she harmed Gannon multiple times, multiple ways, right? I could even see her being able to claim that she snapped and stabbed him or something along those lines, you know, the 18. I said 22 yesterday. It's actually 18 different stab wounds that he had. I could see her saying even that was out of rage and she snapped or something along those lines. But how do you prove a gunshot that she had to leave the room, go get the gun, come back and shoot him? I just don't see that. And not just one, but three. There's no way. Psychological diagnosis is mainly opinions. So for me, I don't hold much weight by it. Right. That's the thing too, because how do you, I don't know. How do you know that my opinion is valid and what I am saying is truthful or what I am saying is the most accurate thing that you should look for?
No, I'm an adult. Oh, you didn't watch me now.
If I hang out with Will, I think he was more mature, responsible.
I like that approach. That's good.
Rodney Dangerfield in old school. You want to look center, hang out with better people.
Sorry, I keep muting again because I'm not sure if they're getting ready to talk or not. We still have 7 minutes before the jury comes back in.
I don't know.
This makes it hard to do this. Like, let's figure.
I think we're gonna need that actually. We'll start doing that.
Hard here.
Yeah.
No.
I don't need to make a record. I'm just need to stand up some.
I have two issues that I want to discuss with the juror, with the attorneys. The first one is juror 16, who I do not have as a person I'm going to excuse at this point in time, says that, or she informed my clerk that she's asking for another hearing device. She says she can hear me fine when I'm using the microphone, but could not hear hardly anything that was being said in the back of the courtroom. So I don't know if it's going to be an issue at the time of trial. It certainly would be an issue for the rest of voir dire. So I don't know what you want to do about that. Prosecution.
So what I've noticed, Judge, is that she's distracting the people that are near her too, because she keeps asking them questions because she can't hear.
Okay.
And so I think she's exhibiting
No,
particular difficulty. So I'd be fine if you want to release her.
okay.
I would concur.
Okay. I did not notice that because I was watching what was going on in the
So
section that I
that's
was at.
16.
Yes. And then the other issue is with respect to juror 22. Juror 9, I think, is a clear excusal. Juror 22, I think probably is your position, prosecution, based on his employee. He's the city employee that works for CSPD, although he's a civilian.
Yeah, so he is not a law enforcement officer. I don't think by statute that he's an automatic release.
Mr. Defense?
He's in a compensated employee of a law enforcement agency.
Yeah, it's, you know what? I think I'm gonna leave him on for just now. Actually, I've got time. I'm gonna run back to I'll be back in just a minute.
I mean, the statute is compensated employee.
Well,
So it's just like, I mean, if there were a secretary of the public defender's office, it would be off.
right. And I know that there's some cases on it, but I don't have my laptop.
And the cases generally go for like people who work for other things, like if you're in the military, but you're military police. Or if you're working for something, you're a law enforcement agent in that company.
Hey,
That's not necessarily primarily.
Gary, can you grab my laptop off of my desk? You'll have to unplug it and just bring it down. Thank you. I'm tending to side with the defense here, but I want to take a look at some of the research that I have on my laptop. So I will probably keep him here until I take a look at that, and then we can raise it again. But I think Mr. Tellini's right. So before we bring the jurors in, these are the jurors that I intend to excuse. We already excused juror number 1 and juror 20.
And 16.
No, not yet.
Well, will be, yeah.
Will be. So these are the ones that I intend to excuse in addition to those. Juror 3, juror 5, 7, 8, 10. I can tell that Mr. Cook is following along. 11, 12, 13, 15, 18 has already been excused. 23, 25, 26, 27. Thank you. 28, 30, 31, 32, 41, 42, 44, 45, 46, 48, 50, 52, 54, 56, 57, 61, 62, 63, 64, 65, 67, 68, 69, 70, 71, 72, and 75.
You have to go through this.
Yep. It is. And we're just going to excuse her, so we're done. Yeah. Oh, I did not. I did not. So we're going to excuse juror 16 as well. Sorry about that. And juror number 9.
9.
Yeah, he's the Homeland employee.
I must have missed something on 13.
13, I did excuse. 13 was, I should not have excused 13.
Yeah, that's what I
No,
thought.
13 stays in. I'm sorry. 13 is not excused. 11, 12, 15, it should be 11, 12, 15,
Yes, okay.
18, 15, 16, and 18.
Oh, 16?
16 is
Oh,
the
yes,
hearing problem.
Yeah, yeah.
Are you researching 22, Your Honor? Gonna let
Yes,
go with
I
the
am.
match, or-
I am, and yeah, because I don't think he has to be a sworn officer.
I mean, the statute, I'm looking at 1610-103.
Hold on. Go ahead.
1610-103 subsection K, the juror is a compensated employee of a public law enforcement agency or a public defender's office.
Right. And there was a case that I was looking for that I have in my research. Let me see if I can find it. But I think that was sort of the issue is the person was not a sworn peace officer, but was employed by, I thought it was a sheriff's office, if I remember the case right. We can go ahead and bring the jurors in.
I thought we were gonna discuss these.
Yeah, right over there, 1, 2, 3 over.
Just stay right here until we can put the chairs back.
There's one more to go down the road.
Yeah, I have to stay. I just didn't want to move the chairs if there were still people coming. Everything even went out.
They were figuring out the list of jurors that they were eliminating. It sounds like they're eliminating 45. The jurors are in the process of coming back in, and then they'll eliminate who they're eliminating, and then the prosecution will give its opening statement, and the defense will give their opening statement,
Okay.
and then they'll ask more questions.
Right. It doesn't work well. number 7, 8, 9, 10, 11, 12, 15, 18. You guys are in the wrong seats, right?
No, I'm in the right seat. This one here, 20 is gone, remember?
20.
Yeah, that's right.
Yes. Threw me off there. Wait a minute, wait a minute. Okay, all right. So 18, yes, you're in the right spot. I see what happened. Just need to chair, so that's okay. 23, gentlemen here. 25 in the sweatshirt. 26, hidden buffs, bluffs. Hidden bluffs, yeah. Okay. 27. 28. 30, 31, 32. Starting again over here, 41. 42, you'll be excused. 44. 45. 46. 48. 50, second gentleman, or the gentleman, yep, you would be 50. 52. 54. And 6. 57. 61 and 62. In this row, 63. 65. 67. 68, 69. In the back row, 70. 70. 71. 72. 75. So the people that I've excused, you are excused with the thanks to the court. You can go ahead and leave the courthouse.
Thank you.
Back at the jury assembly.
I know. We're gonna do that. Okay.
Oh, you're going again.
All right. Okay. Now, you do have to remember where you're sitting, but especially those people in that front row there, if you want to spread out a little bit more, it's okay if you want to do that. You do have to, it is still the third grade C. It's okay. You know, togetherness is a good thing. It's all right. But if you want to have a little bit more room and spread out a little bit more, that's okay too. All right. Oh, I see what you did there. I was going, wait, who's that? And okay, I see what you did. Nope, that's okay. It's all good. All right. In juror 22, I want to ask you a little bit more about your job. Because you're a civilian, but you're employed by the city of Colorado Springs, right? So you're not employed by the Colorado Springs Police Department. You are, but you work at the police department.
I am employed by Colorado Springs Police Department as a city employee. I work for the city, but I work in. Yes, we do.
Okay. And that's what I'm trying to understand because how it's the city that pays you, right?
Correct.
So it's the city that pays you as a city employee, not the Colorado Springs Police Department that pays you.
I'm employed by the police department.
Who do you report to? Who do you report to?
I work out at VOC.
When something goes wrong or you have a supervisor, do you have a supervisor?
Goes out for chain of command. This SPD.
Okay, that's what I wanted to know. All right, I'm going to excuse you as well, sir.
Thank you.
Okay. All right. At this point in time, I'm going to give the attorneys an opportunity to give you sort of a 2-minute mini opening statement, and it's really just an opportunity for the attorneys to tell you what they think the issues in this case are. It's not necessarily what you'll find them to be if you were selected to serve as jurors. So with that, prosecution.
Thank you, Your Honor. Good morning again, everybody. This case is about two people. One of those people is Gannon Stauch. He was an 11-year-old boy who lived with the defendant and his father, Al Stauch, in the Lorson Ranch neighborhood, which is the southeast part of the city near the Colorado Springs Airport. The other person involved in this case is the defendant. You'll hear evidence that Gannon was a fighter from the very beginning. He was born premature, weighed 1 pound 6 ounces. He fought to live, and he fought in the last moments of his life. The evidence will show that he was stabbed 18 times, including defensive wounds to his hands, arms, his back, his armpit, that he was hit with some blunt object that caused his skull to fracture. You will also hear that he was shot 1 time in the jaw. You will hear that he died in his bedroom, a safe place for most 11-year-old boys. You will hear then that he was stuffed into a suitcase, loaded into the back of a van, and driven from Colorado Springs to Pensacola, Florida, by this defendant. You will hear that she then threw him over the edge of a bridge and left him there. His body, his mangled body, was later recovered, closing the circle on what happened to Gannon Stauch. At the end of the presentation of evidence, we're going to come before you again, if you end up on this jury. And we're going to ask you to convict, find the defendant guilty of murder of Gannon Stauch, a little boy who fought to live and fought before he died and fought this defendant. Thank
Right.
you.
Thank you. Before we start the defense argument, we're going to make a change here. No, it's the one in the podium.
This one here.
Pull it out and leave it out. Otherwise, it's causing echoing. So it was
That was my plan, Judge.
okay. All right, Mr. Cook.
Good morning, ladies and gentlemen. My name is Will Cook. I represent this lady
Yeah, that's a lot better.
at the table in the blue shirt, Letecia Stauch. Ms. Stauch has been charged with committing first-degree murder against Gannon. We all know why we're here. You've known it since you filled out the jury questionnaires this morning, and it gave a summary of what's going on. A lot of what Mr. Allen just said is true. You're going to hear circumstantial evidence that Gannon was killed, he was stabbed, he was shot, his skull was fractured. He was taken to Florida, Pensacola area, his body in a suitcase, and it was thrown off an overpass of a highway. His body in that suitcase remained in the Florida heat for 6 weeks. If you're on this jury, you're going to see photos of the autopsy and this body. You're going to be horrified, disgusted, destroyed, and tormented if you serve on this jury. And we're not saying that this happened and she did it. But you're also going to hear some more information that Mr. Allen didn't discuss. You're going to hear, and it was mentioned in the jury questionnaires, about insanity. You're going to hear about dissociative identity disorder. An acronym is DID, dissociative identity disorder. Used to be called multiple personality disorder. You're going to hear from Dr. Dorothy Lewis, a doctor from Yale University, who's going to
Wrap up your comments, please.
testify that Ms. Stauch, at the time of this crime, suffered from DID. And that in fact, she was legally insane at the time of this crime. After all this information, weeks down the road, we're going to come and ask you to find our client not guilty by reason of insanity.
Right. Thank you. I want to read some of the instructions that you will receive later because I think that they will help guide our discussion going forward. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to tell you, or if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case and the defendant is presumed innocent. Evidence in this case would be exhibits. It would be somebody who comes forward, raises their hand, swears to tell the truth, takes the witness stand, and tells you what they have to say. Nothing that the attorneys say ever is evidence. They don't take any oath to tell you the truth. They are here to present evidence. They are advocates. They are paid advocates for the position that they want you to believe. So nothing that you've heard yet is evidence. In addition, someone may ask you whether or not you think the defendant has done something wrong or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in the courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against this defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. The defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may also find it useful to think of the charges in this case as similar to a recipe from a cookbook. That's because when you see the charges, they have certain things in them that the prosecution must prove beyond a reasonable doubt. For instance, suppose that you wanted to have a Denver omelet, you took some eggs, you scrambled them up, you added some ham, you added some Swiss cheese, and you added some mushrooms. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, that's what they have to prove. No substitutions on the menu are allowed, and proving something else doesn't necessarily prove the elements of the crime with which she has been charged. The prosecution has to prove beyond a reasonable doubt what it has charged and not something else. I also want to talk for a moment about the defendant's right to remain silent. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everybody wants to be fair, right? And you can only do that if you hear both sides, right? I mean, for those of us who are parents, we look and something happens with our children, we go in there and say, okay, what happened? Okay, what happened? Well, that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. Stated differently, the defendant does not have to present any evidence or any testimony. In fact, defense counsel, I suspect or not, but defense counsel could choose to do nothing or take a nap at the counsel table, and that would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it is not evidence, does not prove anything, and cannot be considered for any purpose. Now, sometimes the attorneys will ask a question of all of you designed to elicit a response from you, such as, well, I know that if I were accused of something, I would take the stand and I would talk until everybody understood my side of the story. As I indicated earlier, however, that's a trick question because that's not the process we follow in a court proceeding. In any event, does anyone here know what the number one fear in the population is? It's greater than the fear of death and greater than the fear of running into a rattlesnake on a hiking trail. It's the fear of public speaking. So naturally, the first thing that we do is bring in as many strangers as we can pack into a courtroom and have them start talking in front of a bunch of other people. And I want you to think about that process for a moment. When you were asked a question, were you nervous? Or were you going, if I sit here, maybe they won't call on me? And you weren't sitting there in the witness stand, subjected to questioning by attorneys on maybe very difficult topics with a whole bunch of people just staring at you and realizing that they were going to decide what the facts in the case were. The bottom line is that it is possible that the defendant won't testify. It's possible that the defendant will testify. But regardless of who testifies or who doesn't testify, and regardless of whether you hear something more from someone or not, the real question at the end of the day is always the same. And that is based on the evidence that has been presented, whatever that evidence is. Has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone here who thinks that they would have to hear from the defendant before they could decide the matters in this case? Please raise your hand. No response. You've heard us talk a little bit about what this case is about. You heard it or you saw it in the questionnaire. You heard what the attorneys had to say. And I do want to ask, have any of you heard anything about this case from any source, including friends, family, the news, or other media, or the internet? Please raise your hand. A lot. Almost a lot. Okay. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media or heard something from your friends, the real question is whether or not you can put that aside and decide this case based on the evidence you hear in this courtroom. For those of you who raised your hand and said that you had heard something or seen something in the news, on the media, from a friend, anything like that, is there anyone who thinks that they cannot put that aside and decide the issues in this case based on the evidence they hear in the courtroom? All right, start over here. Juror number 2. Yes, sir.
I just feel I have a strong bias and it's going to be difficult to set that aside.
Okay. And is that based on, I'm just trying to figure out the source. Is that based on media? Is it based on conversations you've had with people? Media. Okay.
And life experience.
Okay. Now, in this case, you heard me tell you about nothing that the attorneys say is evidence, and the only evidence comes from somebody who sits on the witness stand. I can tell you that, at least in this case, nothing that the media has said is evidence either. They may have reported certain things. They may have got it right. They may have got it wrong. The question here is whether or not you think you can put aside what you've read and decide this case based on what you hear from the witness stand.
I think it's possible, but I think I have a bias.
Okay. Did you have your hand up, sir? Okay. And you are juror number 6. Yes, sir.
Yes, I have seen in the media the arrest warrant was posted online. It had many photos that coincide with the description that we were given by the DA. I understand none of this is evidence. And the civic cast that aside and be as unbiased as possible, but I'm afraid that I may not.
Okay. In the front? No. Over here in this group. I'm trying to figure out, I think that you're probably just resting your hand, juror 35, just making sure. It's okay. You can put it back up. It's all good. Just making sure. All right. Juror 55. And over in this section. All right, let's see. 1, 2, 3. Juror 59. Yes, ma'am. Okay. And juror number 60, did you? Yes, ma'am. Okay. I'm gonna ask the the jurors to look around the courtroom. And the question that I have is, do any of the potential jurors know each other? All right, no response. This question is separate from the media. But is there anything about the nature of this case which would in and of itself influence any of you at arriving at a verdict? And in the back, juror 73.
I've heard everything on YouTube.
No, I appreciate that. And, you know, I've done this for a long while and I've presided over a lot of different cases and including child abuse and sex assault on children and those sorts of things. And no one ever comes in and thinks that this is a good thing, right? They always, this is a terrible crime. When you bring them in for a sex assault, they say, well, it's a terrible crime. It's a crime that involves a young victim. And there's not anybody that's going to argue that somehow that's justified, such as, you know, a self-defense in a shooting or something like that. But we still have a process that we have to work through, and it sounds as though you have some feelings, but you think that you could follow the law in this case and do the best that you could regarding that. And you think that you would, well, let me ask it this way. Do you believe that you would be able to follow the law, give the defendant a fair trial? All right. And juror number 74, did you have your hand up? No. Okay. I just wanted to make sure. I wasn't sure if you did or not. Is there, juror 24? Yes, ma'am.
I am 15 weeks pregnant, so I don't know. I'm pretty like emotionally down as of now, but coming up with priorities, many upcoming emotions.
Okay. Well, assuming that it stays that way, do you think that there's anything about this case which would in and of itself cause you difficulty serving as a juror?
I know.
Okay. All right. Anyone, juror 36? Yes, ma'am.
I put on my case that I do have a 17-year concept of any being done to a child, up the process, and I would want to make sure it's fair, because as you explained, words like that doesn't always lend itself to life.
Right.
Story.
No, I appreciate that. We all bring in our own set of circumstances with us when we come in. We all have our own past and our own experiences. And the law, you know, you're not required to set any of that aside, frankly. That would be A, impossible, and B, sort of kind of ridiculous. I mean, I don't think we're going to get any kind of fairness in the law if that's what we require is just a bunch of robots to come in. But what you can't do is allow your emotions to overcome what the law and the facts show. And by that, I mean, you know, years and years and years ago, you would have a mob that would say, this is what we need to do, and this is what we need to do, and we need to take retribution, and there's no due process, there's no following of rights, and that's not what this process is about. So what we do require, and you actually get an instruction that says it, that says you shall not be influenced by sympathy, bias, or prejudice for or against any party. And you have to decide the case based on the facts and based on the law that I give. Do you think that you can do that?
tell you 100%.
Okay, fair enough. Thank you. Anyone, juror 34? Yes, sir.
Share the same, 50. I have a problem with it. In my own mind, I don't think it's got along in the process, but I just wanted to share that.
No, I appreciate that. And for a lot of people, I mean, I had this yesterday, actually. A number of people are going, I have a problem with the insanity part. And it gets really to the foundational bedrock of the judicial system, because essentially what the judicial system is intended to do, I don't know if there's any, are there any people with psychology backgrounds in here? Okay, have a couple. What it is intended to do is modify behavior. Okay, I mean, and the idea is if you're doing something wrong, and we're not going to get into morality and stuff like that, but the issue is whether or not there's something that's against a statute, so it's illegal. Let's put it that way. If you're doing something illegal and we don't want you to be doing that, there is a punishment that goes along with that. And the idea, hopefully, is that somebody else perhaps sees that, you see that, and know not to do that. So you get a ticket and you know that you're not supposed to do 70 miles an hour in a 55. So the idea is, I don't want to pay a ticket again. I don't want to get a ticket. I don't want to have to pay that fine. I don't want to get the points. I don't want to have to deal with the DMV. I don't want to go to the administrative hearings. This is going to be a huge hassle. So the idea is that there's a lot of bad potential that comes out. So we say, I'm just going to drive 55. That's just easier. Okay. So the idea behind criminal law is to modify behavior. There is a penalty that is put in there, or punishment that is put in there so that behavior will change from the person who's doing it or may do it. Because other people, and it works as a deterrence for other people, because other people see, well, my friend got a ticket and he went through all of this. I sure don't want that to happen to me. So there's a deterrence for the population at large. There's a deterrence for the individual. And that sort of makes sense, right? I mean, we're going, yeah, we want people to behave in a particular fashion for our society to function. But the law also recognizes that in some circumstances, there may be a person who cannot conform their conduct, or does not understand right from wrong, or does not understand the mental process that is necessary for the action to occur. And when we have those types of cases, the law recognizes that those people they're not in the same category as somebody who can modify their conduct. And that's why the insanity plea is allowed, because there are some circumstances when everybody would look at it and say, yeah, we understand that this happened, but there's something that's going on such that they ought not be legally responsible as somebody else. Does that make sense to you? Okay. Is there anyone else who has any questions, comments, or thoughts about that? No response. In addition, in this case, this is not a death penalty case. You're not going to be deciding the punishment in this case. If any punishment as a result of any verdict that is returned, whether it be guilty to the charges, not guilty by reason of insanity to the charges, that would be decided by me. So there's not anything that you have to decide there. Essentially, what the jurors have to do here is make a determination based on the facts and the evidence that's presented, what happened, and what was the mental state of the defendant at the time. Remember when I told you that this is kind of like a cookbook? When you see it, you will see that the instruction for the charges, they always start out with, in the state of Colorado, on the date or place, and then they give the date of the offense. And then there's a number of other elements. The very last element will be, and let's see, I can't remember whether it's phrased in was she sane at the time, or did the prosecution prove that she was sane at the time or not insane? I can't remember how it's phrased, but you'll have all of those elements. And what you have to decide is whether or not the prosecution has proven each and every one of those elements beyond a reasonable doubt. Is there anyone who thinks that they cannot do that? No response. Oh, in the back. Thank you, sir. Juror 59. Yes, ma'am. Okay. And juror 60. Okay.
That was
59 and 60. Yes. All right. There's one other thing that I wanted to talk about very briefly. Council approach, please.
Jeez Louise, allegedly innocent. I am so sorry that I just muted you or blocked you or deleted that message or whatever the heck I did. My phone has like a shake to block thing, and I haven't figured out how to shut it off. I was out in the kitchen though, getting the kids their snack, and I looked down and I'm like, oh my God, how did I just do that? What did I do? So sorry about that. It was not intentional.
All right, ladies and gentlemen, what I'm going to do at this point in time is I'm going to excuse jurors 59 and 60. And then, so you can go ahead and go. And what we're going to do is we're going to hand out a list of witnesses. It's a number of pages. I want you to look at all of the witnesses. And the question that I have for everybody at the end is, do any of you know any of the potential witnesses in this case? The whole thing. It's because some of them are what we refer to as lay witnesses. That is maybe an eyewitness that saw something. They don't have a particular expertise. And then there are others who are experts. So yeah, you do need to look at all of them.
Can you walk me through what your experience was here this morning?
Well, my experience this morning, I was low-key kind of feeling low. I was low-key trying to have a good day. And that's it. I was trying to see my peers, trying to seem like the teachers that I like love. But like, why this? I heard shots fired. That low-key made me feel some type of way. And then when
Tell me, you said you heard shots fired, is that right?
yeah,
Okay, and where were you when you heard those shots fired?
I was right over there where Chopper's at, just searching around.
So you were back outside of the building when you heard the
Mhm.
shots fired. What grade are you here?
I'm a junior.
A junior. And after you heard the shots fired, then what happened, Ernie?
Basically, I seen what happened. I just seen like students in the building trying to like duck their heads, like trying to run, trying to hide
Any
from
of the
protection.
potential
And then
witnesses?
when
Well,
I
I'm
looked,
sorry.
I just
Are there any other witnesses that are not on that list that people intend calling? Mr. Allen,
Not from us, sir.
defense?
Is Dr. Ron Niederhauser and Kate Fred who's in this.
Does anyone think they know? Oh, I'll give.
Can you go back to the mic, please?
I will. Does anyone think that they know any of the potential witnesses in this case? Please raise your hand. Juror 66. Who is that? Mr. Allen?
Lieutenant David Manzanilla has always been a El Paso County Sheriff. He's a tall Hispanic gentleman.
And I was going to ask about that because you have on occasion represented governmental employees. So would it have been CSPD? Let's see. Would it have been primarily CSPD or EPSO? Okay. Right.
Most currently as you represent.
Okay. Okay. All right. Thank you. Um, let's see. All right. Here's what's going to happen. We are, I know it's hard to believe, but we are actually getting a little bit better and a little bit more efficient at this. This is our third day in this. The plan here is that what we're going to do is qualify 110 jurors, have them come back on April 3, and then we will select our jury pool from that. So we're getting a little bit faster every day. What that means today is that we're going to break early for lunch. And if I can have everybody come back at, say, 1 o'clock, we should be able to start on time at that point. What you can expect this afternoon is that you'll come back at 1 o'clock and the prosecution will have an opportunity. They'll have 45 minutes to ask you some questions. Then the defense will have 45 minutes to ask you some questions about all kinds of things, including some of the issues that are involved in this case. And then once we get done with that, we will proceed to select the qualifying people who will return on April 3. You've probably already guessed that there is some public or media interest in this case. You may have a spouse or significant other who is generally interested in your welfare, wondering how the jury selection is going and what's going on and those sorts of things. Here's what you can tell them. You can tell them that it is the case of People versus Letecia Stauch. You can tell them that if you are selected as a juror, you anticipate that your service would take 6 weeks, beginning April 3 and going until we're done. And that is all that you can tell them. If they ask, say the judge said, I can't tell you anything more about this. You can enlist their help in saying, help me to avoid any media exposure to this case. If there's a story that comes up, you need to not look at it. If you see a headline in the newspaper, don't read the story. You just need to put all of that outside of your mind. I know that, when I go home tonight, I'm going to talk to my wife. She's going to ask me how my day went. I'll tell her, and she'll start talking to me and I'll tell her about something that happened. And she'll say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. So the way to avoid all of that is to say, the judge said, I can't talk to you about this. I can't know anything about this case. I need to avoid it. Help me avoid it. If you see a story come on, turn the channel. If somebody's starting to share their opinions, tell them not to share the opinions, those sorts of things. I think that will help a little bit more. And you can say, the judge said that's what you need to do. That puts the burden on me as opposed to you. Because I know if I were to tell my wife, look, I'm just not talking to you about it anymore, it would lead to an entirely different conversation. So this way, this resolves a lot of that. Most of the eating joints are north on Tejon. There are a few south on Tejon. There's also a bistro that's in the basement. I think it's supposed to be a nice day. Don't get blown into Kansas. Other than that, it should be nice. But if we can have everybody back at 1 o'clock, one of the reasons why we're taking, I'll get to you in just a second. One of the reasons why we're taking a longer break is because we're getting this part done a little bit faster this morning than we have on other mornings. You saw people come in and hand the attorneys a stack of stuff. That stack of stuff was all of your questionnaires. And the first time they saw any of your responses was when it got handed to them this morning. Since then, we've gotten rid of about 30 people, or maybe 40. And so now they need to look at what the question responses are for the people who remain in the courtroom. I think it's fair to allow the attorneys to have a noon hour to look at that. That's what I've given them before. So that's what I intend to do now. So that's what we're going to do. And juror number 37, you had a question? Yes, ma'am.
Can we tell our court what case they understand?
Yes. Yes, you can. You can tell them what's going on, and you can tell them everything about how long your service will be. And what I can tell you is what the attorneys have told me. They anticipate that presentation of evidence will take 6 weeks. Deliberation is not included in that 6 weeks. So that would be the end of evidence, and then there would be deliberation after that. So there'd be some time after that, but they say 6 weeks. Juror 38. No, you might still be dismissed on April 3. Here's, as I said, I've done really long cases before, and here's what I learned. And it's not any secret. We always select more jurors or have more jurors come back than what we're going to need. The reason for that is because the attorneys get peremptory challenges. In this case, they each get 16 peremptory challenges. That's just what they're called. And they get to excuse a juror for any reason or no reason at all, pretty much. So each side has 16 of those. Okay. Then we're seating 18 jurors. In addition, I'm asking you how your lives are now going forward. My experience has been in selecting, especially in selecting cases involving jurors who are going to be here for a long period of time, circumstances change between now and the time that they come back. So it would change between now and April 3. It could be that somebody unexpectedly passes away. It could be that somebody loses a job. It could be that somebody has to move. It could be that somebody a family member gets sick and you have to take care of them. You weren't anticipating that. So generally, we lose about 27, 28% of people because of changed circumstances. In addition, there's going to be other reasons that may occur between now and April 3 why a juror may not be able to sit. I've had some jurors come back and say, thought about this. And in my heart of hearts, I just can't do it. For a lot of different reasons. And so we end up losing jurors. So that's why we're looking at 110 to come back on April 3. And then, but if you need a letter from me saying why you're here today, why you're going to be back on April 3, if you're still standing at the end of the day, I can get that to you so that your employer knows you're not off on a lark in Cabo or something like that. So, but that's sort of the process. Does that help? Does that help you understand what we're doing here? Okay. All right. Juror 55 in the back. No, hallway. Yeah, you'll be in the hallway at 1 o'clock because we open the doors. You guys can't get in them until we open them. So my hope is that we will be opening the doors, have everybody come in. Does that answer your question? Okay. Juror 40. Yes, ma'am. We'll get to that at the end of the day if you're still here at the end of the day. Juror 53. Never too late. Okay. And the question is, and how long ago was that? Okay. The question that I would have for you is there anything about that that you think would cause you any difficulty judging that person's testimony, if it is the same person? Would you be able to judge that testimony just as you would testimony from somebody you didn't know? Okay, thank you. Anyone else? No? All right. All right, thank you. We'll see you back at 1 o'clock. Thank you all. All rise for the jury, please. Are you back this afternoon, Beck? They're switching out. Okay. Perfect. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Then we'll reconvene at 1 o'clock, and we'll go from there.
Sorry, guys. I was like, "Oh, no, I didn't put my crock pot on." Okay. So, yeah, making me hungry. You always joke, not really counted as being from Louisiana. You gotta be south of Alexandria count to count. That's funny. Mhm. I'm making pulled pork. Why did my crisp just shut off? Mm. We haven't seen her yet. I thought that I seen her the very first day walking in because they accidentally had the cameras on, but we have not seen her yet. You're having lentil soup. That pulled pork is gonna take forever to cook. I actually took it out of the crock pot and threw it into a roaster pan and put it into the oven. No, very first day we can't see anything, but we have sound. That's it. Period. No, Vanessa, I'm so glad that you are here. Following up on the Excelsior Springs, yeah. He lived there for 4 years before coming back to crazy Colorado. Ooh. Honestly, I can look at Chasing's video the other day. She streamed the jury walking in, and, I can pull up the person that I thought could have been Letecia so that we can look at it together. I don't wanna show the jurors' faces, though, so give me a second to see if I can see that before they come in, or how long she was on, because we were instructed not to stream the jurors' faces at all, and I don't think that she did it intentionally or whatever. WebEx cameras should not have been turned on, and they were. And so we were able to see the jury and everybody walking in. But there is no. See, she's sitting behind the computer over on this side, so we can't see if she is here. Let me just screenshot this, then I'll blow it up for you guys. They have her kind of tucked in the corner. You can see the top of her greasy head. That's about it. But I'll screenshot it and then I'll pull it up and blow it up for you guys so that we can look at it a little bit better. You just grabbed a Hi, KK. They released a lot already today, like 46. Or no, they start 46. They just released 2 more, so there's 48 gone already. So they just sent them to lunch. Yes, WebEx was at fault, not chasing. I don't think it was. I mean, honestly, I just chose not to show it because I knew, like, whatever. But with the instruction being that we could stream the WebEx, that's like you said, WebEx's fault, not ours, not hers. Okay, so here she is. You can see her kind of tucked in. It's a little bit pixelated because, the WebEx cameras are not the best, but she's tucked in the corner here. That's the defense side over here. And then this is Mike Allen and the prosecuting team. But they didn't have her coming into the court, just once they were already seated. Here's another shot. And I know it's her because you can see like the glisten off of her hair. She doesn't wash it. She didn't wash it though before she went in. So I don't think it's a jail thing. I think it's just a Letecia's hygiene thing. She's always greasing it up. So 45 out of 75. They started with 75 this morning. Yes, he was called as a witness. Exactly. You're drinking wine. That's funny. Oh my goodness. Okay, so wow. Yes, grease. Yeah, she's greasing it up. She always, always, always was like real greasy looking even before. So I need a little backwards interview. Mm. Right. They have soap in jail. She just chooses not to use it. Meanwhile, she's complaining about her she's complaining about her rights and her civil rights and stuff like that because they wouldn't give her proper toilet paper and things like that. And it's like, I doubt it. Right. We had 75 at the start. So 75 minus 48 is what we're looking at right now, which is 27 people left that just got sent to lunch, and then they will be back. And so he said 3:15 again, I believe. Or did he say 3? Seems like he tries to stick with the same timeline, really. Yeah, her kosher diet too, right? Right. Maybe she needed kosher shampoo. I don't know. I don't know how that works, but I don't know. So I want to keep going through this arrest affidavit though, because I haven't done that yet on my channel. And I know that there are several of you guys who have not heard all of the details of this case yet. I know, not math again. We don't do math very well, especially not on the spot. Thank God that I have a computer calculator down at the bottom there that I was able to easily click on. I made it a little file thing now so that I could stop embarrassing myself. Yeah, she was insane enough to kill him, but she was insane enough to kill him, but sane enough to plan his hiding, talk to the cameras, flee, dispose of him, write notes to go in and talk to the police, right? Have interactions with multiple people online via Facebook and emails and everything else like that. All of the different things that she did, but she was insane. So it's going to be interesting. Did anybody else watch the HBO documentary on her doctor? Crazy, not insane. I did not. I know that there have been people who have. that have been talking about it. Let me look this up. Hmm. So let me pull this up. Oh, of course. This is from Yale University. And it talks about her. It says Dr. Dorothy Lewis has spent her career trying to understand serial killers such as John Allen Muhammad and Ted Bundy. Her theory, all violent offenders share three traits and was once considered outrageous but now influences Supreme Court decisions. This is from 2007. So she's a pretty major doctor for them to have called upon. I mean, if she is influencing Supreme Court decisions. This says Lewis records, or sorry, her records include writing samples and drawing from the killers she has studied. The style of these records tell her that as much as the substance, marked changes in handwriting can reveal as much as what is written. Says she believes that child abuse acts in several ways to turn people into violent adults. The abuse itself can cause brain damage that leads to a lack of control. Children also learn unhealthy model of behavior. Children do as they see, Lewis said, and the abuse endangers rage that is almost never directed towards the abuser, but displaced on others. So I guarantee you we will hear that whenever she is testifying. She will likely say that Letitia's rage that she had towards Albert and Landon and other people was displaced onto Gannon. I bet you any money we hear that sentence. I don't know why there's a picture of cats. Among the murderers and serial killers, Lewis has studied Ted Bundy, Mark David Chapman, and the Beltway sniper John Allen Muhammad. The first murderer she evaluated was a 13-year-old schoolgirl who killed her best friend for reasons she could not explain. Among the murderers and serial killers, Lewis has studied. Oh, yeah, it says the same thing again at the bottom. So that's interesting.
Hey, Lily.
So, and then it gives you a background of her. She talks about her childhood and things like that. Um, yeah, I don't know. It says she is a master at separating the lurid side of her work from her family. On a snowy afternoon last winter in her comfortable Tudor home in New Haven, a boombox flooded the house with Mozart. Lewis sat on the sofa, thumbing through case records. Her records are full of drawings and writing samples from the murderers she has examined. There are sketches that they made of their own disjointed conceptions of their brains, as well as scenes of sexual abuse they remembered from childhood. Lewis often saw as much in the style of their works as in the substance. See here and here again, she tapped the pages wherever she saw marked changes in handwriting, clues that the writer may periodically dissociate. And so we talked about these letters over the last couple days and the different things that the letters would probably end up playing into this. I would not be surprised if the letters were taken down from KitKat and other places, because what if the defense is going to be using those? Yeah, she's just evil. She made her reservation the night before she arrived in Pensacola. Not insane, just evil. She hurt him over a numbered days. I agree. Wonder if the doctor will use all of her Facebook posts and her conversations. I guarantee it. I guarantee it that that'll be part of her proof as to why she found her insane. Definitely worth a watch, not just because of this nut case, but overall. Good to know, Ramblin' Rome. I will check it out. Yeah, she's gonna blame her childhood, probably her own daughter, probably Albert, Landon, all of the people that she ever was angry at. She'll probably even say that T saying that her dad died that morning in a car accident was part of why, like, it was part of her displaced angst, right? Remember, like, blaming it on on them. If you want to give me your email, allegedly innocent, I can send them to you. I will tell you, some of them are hard to read because the YouTuber who posted them, Kit Kat, she put her like thing over them, and so it's really hard to. Plus, they're really blurry. But let me show you. You want to send me your email though, or shoot me an email, and then I'll email them over to you. But like they get very hard to read, some of them. But she talks about being a different person. She talks about being in vampire training. She talks about being named Taylor and Janelle. You know, she has all these different things that she discusses in these later letters. See right here, it says, I changed my name to Janelle. And she talks about how she lost a year of her life and she woke up and she's in jail and being told she did all of these awful things to Gannon. And then in this letter, she talks about the experts in handwriting experts too. And I think that that was her, you know, plotting and planning to do the DID, um, to pretend that she was different people. And so she purposely alters her handwriting through these letters. So these are the ones to Kit Kat. And then there are the ones to Wicked Truths. Let me just pull up their channel real quick because we have that video link there. And I think all of that is going to play a part in how they're trying to prove her DID, how they're trying to prove that she wasn't a monster, that she just couldn't help herself. All right, let me pull this up.
There you go.
Give me 1 second for the Wicked Truths ones. This one is a 10-minute video. She reads these. So they are here for that. But you can see just from the screenshots to these ones, they are completely different handwriting, completely different signatures, and all of those things. And then here's a different letter, again, completely different handwriting. And so I think she was purposely writing the YouTubers and things like that so that she could get a sample of her writing as many places as she could, each of them different, as part of her wanting to get the DID diagnosis. So, hi, Amelia. She is ridiculous. Absolutely ridiculous. Yeah, good luck trying to convince a jury of all of that mess. Exactly. Oh, no. You just, that's so funny, Amelia. I do that all the time places, and then I'm like frustrated because I'm like, oh, I gotta wait 5 minutes, you know? So there is that. Yeah, you're welcome. Absolutely. Okay. Where's I at? So until 1984, when she recognized her first case of dissociative identity disorder, she questioned the phenomenon's very existence. It is still regarded with skepticism by some psychiatrists. Yeah. Once known as multiple personality disorder, DID is marked by 2 or more personalities coexisting in the same patient. While DID has been listed in the 4th edition of Diagnostic and Statistical Manual of Mental Disorders since 1994, the diagnosis remains controversial. Some psychiatrists believe it is the product of therapist suggestion. So somebody at some point suggested to Letecia, or she suggested it to herself, looking and searching for a way to get out of this, that it exists. Nevertheless, Lewis is now asked to lecture about it internally. Evidence, in her view, that the profession is giving the diagnosis more credence. So that just gives you kind of a brief oversight of who we are dealing with here. You know, this is what she does, and this is from Yale. I mean, it's from 2007. That's a long time. Do you want to say hi?
Say hi.
Yeah, she's been in jail with too much time on her hands. Exactly. Sorry. Sorry about that. So yeah, so that'll be interesting to see how that goes. I really want to hear what this woman is going to say and why she took so long to respond and do all of the things that she needed to do. Yeah, some people suddenly discover their spouse has DID when they catch the spouse cheating and the spouse says, "Oh, I'm DID. It wasn't me. That that was cheating." I'm sure. Devil in disguise. That's a good one, Loopy Housewife. That's a very We found out yesterday during the defense that it was a diagnosis. You don't believe the doctor, Letitia. You don't want to pay for her either. Oh yeah, throwing a temper tantrum. That's right, because you're in Colorado. This is what you're paying for. Yeah, I missed it too, Amelia, honestly, the first time through. And then whenever I was reading through the different tweets and stuff from yesterday, I seen this and I was like, wow. So they did talk about Dr. Dorothy Lewis. So very interesting. Okay, so looking at the DID diagnosis in reference to this arrest affidavit. Again, I'm going to tell you guys this arrest affidavit was written on February 28th. That is 4 days before Letecia Stauch was arrested. And I don't know how many days, but you know, more than 2 weeks before Gannon's remains were found, because his remains were not found until March the 17th. And so some things that we know to be different now based on the preliminary hearing are not reflected in this document. And so while there are a lot of amazing pieces of evidence and things in here that can give you insight into this case, please keep in mind that during the preliminary hearing, we found altered details to some of the things that they say, as well as you know, things changed. Things just changed. For example, one big thing being that this says that the switch wasn't found. I will tell you from talking to Bobby Owens and multiple other people that the switch was in fact found. And you can find screenshots of Bobby Owens showing that in one of my videos that the switch was found. So that is one thing that, for example, differs from this document. You would love to know what research she did on mental illness. To be diagnosed, she must have been pretty textbook. You know, I think that there is a good chance that that's what she utilized her jail library time for, was making sure that she had all the ins and outs of this illness so that she could get the diagnosis. So ultimately, investigators located video surveillance from the neighbor's surveillance camera footage that showed what investigators believed to be Letecia and an individual that appeared to match Gannon's physical description depart from the residence in the Nissan Frontier at or about 10:16 in the morning on January 27th. The video camera is several homes away and does not provide images clear enough to make positive identifications of those captured in the recording. The vehicle returned home at about 14:19, so 2:19 in the afternoon, and Letecia exited the vehicle. After viewing the video, I could not be sure if another person exited the vehicle or not, but I submit that Gannon likely did return home with Letecia that afternoon. These times are corroborated by data collected from ADT security system installed in the Stauch residence and are discussed below in more detail. So, what's you guys' thoughts on him returning home or not? Yeah, it was found under the TV. That's where they told us it was found. Yes. And so I want to pull up this video camera footage because there are some people out there who do not believe that he ever returned home. And I want to say, like, I do not think that it's possible that the blood evidence, we talked about that at the beginning, that that he would have been harmed and then able to walk out to the car. So I'm going to show the video footage again. This is a more zoomed in copy, also from Wicked Truths. And so this one, I think they also have it go in slow motion. But you can see T, she goes out to the truck. She gets in. And then she backs up into this driveway. I don't think he walked into the house, but I do think he came home. The Sonic emojis I added for Gannon. I make his full screen so you guys can see it the best. So she backs in, and she has a difficult time backing in. She's not the best at that. Now, keep in mind, we can't see the opposite side of this truck. There is a camera that is directly across the street from them, and there is also one down at the other side of the road. And so I believe that there will be more video footage that they have of her coming home. They just may not have had it at the time that they were writing the arrest report. They may not have wanted to disclose that they had it either. So she has Gannon come out, and it's believed that he dropped something and he won't even bend down to pick it up. Then Letecia comes out, she picks up whatever it was that he dropped, kind of helps him into the back of the truck, and then they leave. And like you see how kind of like blurry almost this is, like it's not, and that's why they said they cannot make clear, definitive looks to who it is, right? It's just believed that it's Letecia and Gannon. Yes. Hi, Connie. How are you? Right. Whoever she is at the moment didn't do driving test, right? whoever this personality is that was leaving this day didn't do a. So whenever they are pulling out, I want you guys to keep an eye on the bed of the truck. We've seen her walk out with a backpack and things like that. But keep an eye on the bed of the truck. And it's important to note there was no blood evidence found in Albert's truck. And I have reason to believe that if she had done so many brutal wounds to him inside of the house prior to leaving this day, to put that blood evidence there, that there would have been blood in Albert's truck, but there was not. No. Hey, you asked it as soon as I was saying it. No blood evidence in the truck. Now, it doesn't mean that there's not other bodily fluids or whatever, but there was no blood in this truck from what I was told. Yes, you love that the judge has ordered the sheriff to get her to court every day by all means necessary. I do too, Mel. I do too. So they take a second to pull out, and she had mentioned online that, well, we took a selfie that day. So right here, you can see stuff as she's pulling out. I'm going to go slow. You can see something bounce up in the bed of the truck. Let me play it on slow motion. As she's pulling out, look, she hits the bump and you can see something move. It pops up, right? And then it goes back down. I personally believe that that was the suitcase. I think she brought him home in the suitcase and that it was already in the bed of the truck, either from Albert packing or she had took it out there the previous night, whatever. I think she brings him home in that suitcase. That's just my opinion. I don't know if that's fact or not. But if they don't have camera footage of him stepping out of this vehicle from the other side, then I think that the reason she goes back in through the garage and makes it a point to not be seen on Roderick's camera again is because she takes him in through the garage in the suitcase. That's, again, my personal opinion. You put it back on regular speed. Can we expect to see her in a straitjacket in this trial at some point? I wish. Oh, that would be so funny. This is them coming back. This is it 2 something whenever she comes back. I just wanna. It's so hard to see, but there is. Yeah. Wish she would have zoomed it a little bit more. Almost like she sits here for a minute and questions, what am I gonna do here? Yeah, it takes her so long to just pull into the driveway. And I think she was just sitting there panicking inside of her mind, like, what do I do? What do I do? But all of this, like, DID, does it fit? How does it fit? I don't understand. She had more than 3 psych evaluations. I think 5 was our final count. And this time, whenever she's backing up, you don't see whatever it was that bounced the first time. It didn't bounce. Why? Because it's heavier. It takes multiple times to back up and try to get just right. I think she was trying to pull up just right to the garage and stuff so that whatever she was doing, people couldn't see. And she opens that garage door, she slips out of the truck, goes, and we can't see what happens after that. You know, we can't see if she pulls something out of the back of the truck. We can't see if she's taking things out into the garage or whatever. And that's why she did that, I think. She would have walked from the sidewalk up with a suitcase, and then they later found him in a suitcase. You know how bad that would have been? There are some people who say that they think they see a shadow, though, under the truck on the passenger side, and that's when Gannon gets out. But I personally don't see it. I personally have never seen anything that made me think it was him getting out, but I could be wrong. You know, I could totally be wrong. Right here, they say. But I think it's more of a shadow because of her opening her door. Let me show it again. I'll slow it down. So right here, if you watch down here by this tire, I don't know if you guys can see my mouse moving here, but right before she opens her door, you're going to see like a black movement or as she's opening it. Right here. See it? But to me, that doesn't look like feet or somebody getting out on the passenger side simply because it's, I don't know, just so solid looking. It almost looks like it's a mess up because of the way her door moves. Because you see almost the same type of weirdness whenever her door shuts. But you also don't see any movement on the top here. And I feel like Gannon was tall enough that we would have seen him walk. So, but like I said, there are other cameras. And so if he got out and he walked in, they will know that. But if not, then I still think it's possible that she could have taken him home in the suitcase. But again, I can be completely wrong about that. That's just something that has always been, you know, one of my theories that I had. So here's the link to that video if you want to look and analyze that a little bit more on your own. Again, that was from Wicked Truths that they had that. It was released on the regular news though. They just seemed to have it zoomed in a little bit more than what the regular news video was. From what you have read, you were always under the impression that DID takes a long time to truly diagnose. This doctor did it, and I think she was with her for like 8 hours, not even total. I would imagine it was just a short interview and then looking through her evidence, right? His voice is very soothing. Yes. Oh, they absolutely will, Holly Berry. I can almost promise that the police are going to show that during her test or during their presentation of evidence. Surely he wouldn't have to have opened the door and the light in the car would have changed. Yeah, something would have changed other than that tiny little shadow. Yeah, the last time you recall seeing him is when he got into the truck, right? So let me go back to the arrest affidavit. Sorry, I just wanted to show the video since it was talking about it. Okay, so where was I at? Letecia's historical cell site information detailed information about her iPhone status in a text message sent to Harley from Gannon's cell phone to support that Letecia left her cell phone at the Stauch residence the morning of January 27th, 2020. The fact that Letecia left her phone at home is suspicious on its own because based on her history of extensive use of the phone. I've reviewed forensic search records from Letecia's phone and found that she is an active user of social media, including but not limited to Facebook and Instagram. A more detailed review of her phone screen time between January 25th to January 29th revealed that she spent 38,607 seconds on Facebook and Facebook Messenger alone. 10.7 hours on Facebook Messenger, not the actual app. Well, okay, yeah, Facebook and Facebook Messenger. 10.7 hours over the course of a few days. And I guarantee you that probably a lot of that was after the 27th when she was sitting there trying to convince the entire internet of what she didn't do, right? It wasn't her. Everyone owes her an apology. You know, it wasn't her personality that did it. It was the other personality. It was probably Janelle. Probably Janelle. Letecia's telephone was locked at or about 9:56 a.m. on January 27th and unlocked at 2:45 p.m. on the same day. The timing of the unlocking of the device is significant as compared to her departure and arrival to from the residence. It should also be noted by the court, particularly, that Letecia did not open her phone for approximately 30 minutes after she arrived back to the residence. On January 27th, there was a message sent from Gannon's phone to Harley that reads, "Tisha left phone at home. If you need her, text me." So was her alternate personality referring to her leaving her phone at home as Tisha? Wouldn't, if she had DID, wouldn't her alternate personality have said, "Hey, um, you know, Taylor or Janelle left their phone at home. Text me if you need them." I don't understand how they're going. I don't understand how she's saying the idea. I just don't. This message was sent on or about 10:37 a.m. Investigators were able to confirm, based off of video surveillance footage and purchase receipts, that Letecia traveled to Petco located at 5020 North Nevada Avenue, Colorado Springs. That's approximately 22 miles from the residence and is a 30-minute drive based on Google Maps. So she completed her purchase at 11:22 a.m. Gannon is not visible on any of the surveillance video obtained by Petco. Her whereabouts between 11:22 and 1:22 are unknown. She was again captured on video surveillance making a second purchase of the same Petco on North Nevada Avenue at 1:22. She sent a text message to Mr. Stauch sent a text message to Gannon's cell phone at or about 12:06 that read, "Hey, buddy." This message was unanswered until 1:21. The response was, "Can I play Zelda at least?" Mr. Stauch replied, "Not today." A significant event occurred in Gannon's phone at or about 1:43. What, baby? Okay, so let's see. There was an internet search for, "Can my parent find my cell phone if it's off?" I submit that this internet search was likely conducted by Letecia on Gannon's phone and not Gannon himself, based upon the context of the search and the way that the search term was phrased and the presence of quotes in between phone and if. It's very similar to the way, or I'm sorry, a period. There was a period inside of the quote, sorry. A period in between phone and if. It's very similar to the way Letecia conducted searches on her phone. Yeah, I bet you any money it's just because she probably bumps the period a lot whenever she was typing. I know I do that occasionally, where I bump the dots. Yeah, or "Oh, hey, who are you?" Exactly. It just does not. So, let me see here. It says, "However, I located other internet searches with a period in Gannon search history, which I also reasonably believe were conducted by Letecia. A more detailed explanation of her search history is included below in paragraph 141. Furthermore, the search term was parent, singular. I submit that it's reasonable that Mr. Stauch only, not Letecia, would be interested in the location of Gannon's phone, and that Letecia was possibly deliberating on how or if she would dispose of Gannon's phone after she murdered him. I conducted the Google search of "Can my parent find my cell phone if it's off?" and learned that the first returned answer is, "The answer to your question depends on what method is being used to track your location." Gannon's phone was found at the residence. I submit that Letecia did not get rid of Gannon's phone for fear it might be traceable. So the Nissan returned to the Stauch residence around 14:20. A search warrant authorized by this court was executed on the Nissan Frontier and found no indications of blood inside the vehicle. No blood. Letecia had been without her cell phone for hours, yet her screen was not unlocked until approximately 14:45, which was 25 minutes after backing after arriving back at the residence. During that 25-minute period, there is motion activity both upstairs and downstairs on ADT records. Letecia returned home from school at 15:15. During a recorded forensics interview with investigators, Lena stated that when she returned home, Letecia told her Gannon was asleep in her bed and that she could not see him. Letecia told Lena to go outside and play. I submit that Lena was sent outside because Gannon was likely dead, and Letecia was cleaning up blood from inside the house. At or about 3:55, Mr. Stauch sent another message to Gannon's phone and said, "Hey, buddy." This message was not read until 7:40 p.m. It's likely Gannon was already murdered by Letecia at the time Mr. Stauch sent the message. Based on exterior video footage, Harley arrived at the residence in her white VW Jetta at or about 4:42 p.m. and picked up Lena. At or about 4:52 on January 27th, Letecia sent a text message to Harley requesting carpet cleaner, trash bags, and baking soda. These items were likely used to clean up the murder scene. Harley purchased these items, and investigators located a receipt documenting the purchase. Harley Hunt has refused to speak with investigators. Investigators do not believe that Harley was present when Gannon was killed. Harley was at work on January 27th from 8:30 a.m. until 4:15 p.m. Investigators were able to verify this with her employer. To be clear, investigators have not located any evidence that any person other than Lena, Letecia, and Letecia had access to Gannon between approximately 10 a.m. and 5:34 p.m. on January 27th. So that's where they're trying to make sure it's very clear that there is no Eduardo, there is no Terrence, there is no whatever. You wonder if Letecia had the plywood in the back of the truck. I don't think so. I personally think that she put the plywood underneath the suitcase inside of the inside of her T-gon to make sure that no blood would get on her T-gon. I think it was likely probably just a piece of wood that was laying around or something along those lines that was already in the garage that she used. You wonder if the prosecution will timeline the relationship with husband and incidents with children as to why she was fired from her job. Maybe. You think Gannon was her beating boy pre-stabbing, but not before non-invasion acts. Yeah, the daughter is definitely another victim. I fully believe that she was probably physically violent towards these children on multiple occasions, and that she would buy them things or take them places or whatever to win their love back, to try to make it be like, "I'm sorry, guys. Like, I'm sorry you made me do this," right? Because that's what abusers say. "I'm sorry you made me do this. I'm sorry I overreacted." You can hear that same type of language in the video with Gannon whenever she was recording him, and we think that we hear him say, "I'm bleeding," "I'm sorry I snapped. I'm sorry that this happened, but, are you sure it was an accident what you did that made me have to hurt you?" I'm positive that these kids went through all types of crap with that. Positive. Eurofine has reviewed body camera footage. So this talks about when the officers came to actually check on from whenever she called 911 to report him missing. And she did provide verbal consent for the deputies to search the house. They were there at 10:09 p.m., approximately 3 hours after she called 911. So not only did she have from sending Lena outside to play and sending Harley to the store, she had about 2 hours, 2.5 hours initially, I would say, to start the cleanup process. But she had 3 additional hours before the police responded to try to clean up and make this scene look as normal as possible. And this isn't somebody just cleaning, because they want to clean or whatever. This is somebody who was likely, and I would say almost a manic state, freaking out, thinking, what do I have to do? How can I save myself? What am I going to do? What am I going to do? Probably a lot of adrenaline and things like that. And she made mistakes. They found blood on the plugs in the room. They found blood on different cracks and things like that. So she missed stuff. Not only that, but she left the bed away, or she pushed the bed. Sorry, she moved the bed away from the wall. And Albert noticed that right away, that the bed was not where it was supposed to be. Normally it was against the wall. So she made mistakes in what she was doing. Thank God, she was an idiot. Yes, Harley is on the witness list. Yeah, the whole I have to sell the couch. Yeah, you could definitely hear her saying that as well. Alright, guys, I need just a minute to mom for a second. Talk amongst yourselves. I will be right back. Sorry about that, guys. I am back. Okay. Where was I at? Yeah, I could imagine her blaming a 2-year-old for tripping something over something whilst trying to run, etc. Never her fault, right? You're a bit confused about the work history, and you think it's been kept on the download to other children in the programs. Maybe. You were just getting ready to dig into your ribs. That's so funny. No, you can't misbehave. Missed your opportunity, BC. You must be a little bit behind. I'm back. Right. How much did Elle and Harley get abused in Leticia's care? If you remember, there was actually text messages between Albert, Landon, and Leticia that she tried to put out as proof that she wasn't abusive. Okay. To me, psychological torture is really silent killer. There is no external evidence, and therefore it goes unnoticed. I agree. If she wasn't always mentally abusive to that, or physically abusive, I do think that she was mentally, and especially to Harley. A lot of people are really hard on Harley because she was 17. She should have known. Why didn't she know that her mom was doing this? And, why didn't she know everything that was going on? But I would be willing to guess that Harley probably lived a life where she avoided her mother as much as possible because of the abuse that she had endured over her time growing up. I can almost guarantee it. I can almost guarantee it that she avoided her as much as possible and spent as little time as possible around her whenever it came right down to it, especially behind closed doors. You know, Letecia was fun mom whenever they were with their friends or out in public and things like that. But how abusive, how horrible were things behind the scenes? We don't know. Especially with Albert being out working a lot of the time. You know, we just don't know what she was actually doing to these kids behind closed doors. And I look forward to hearing Harley's testimony and see what she has to say about everything that occurred. What did she pick up on? Did she pick on her mom's erratic behavior? I think so too. She was probably frightened of her mother and in fear of defying her. I do too. Sorry, guys. Okay, so yeah, sorry guys, I'm here. They took lunch at like right in between like napping stage, so we're a little bit fussy. Okay. So responding deputies also searched Gannon's basement bedroom. Sorry, wait. I passed up this part. So they looked at the Volkswagen Tiguan, known to be leased by Letecia. It was in the garage, and that is significant, specifically because it confirmed the presence of Gannon's blood in the garage below the area where the rear hatch of the Tiguan would be, and a positive reaction of Blue Star on the Tiguan's rear bumper. Responding deputies also searched in Gannon's basement bedroom, and I have reviewed images of Gannon's bedroom taken from BWC. Below, I have included BWC's image of Gannon's bedroom on the left. On the right, an image recovered from Letecia's cell phone after executing a search warrant that was applied for and granted by this court. These images both represent the condition of Gannon's bedroom on January 27th at about 8:13 a.m. and just after 10 p.m. So she took a picture of his bedroom at 10 p.m. as well. So she took one that morning to prove that he was there, and then she took one that evening at 10 p.m. Yeah, she lies like Casey Anthony. I know. I know. Okay. This photo comparison is significant for many reasons. The corner of the bedroom where Gannon's head is visible is the key area discussed in several sections below. The placement of Gannon's bed is in the immediate location where his blood, based on DNA, was found on the wall, the carpet, the concrete below the carpet. These details are discussed below. And a large volume of blood appears to have been in that area. For purposes of comparison between the images, it appears that although the sheet may not be the same and the blankets are different and the pillowcase, if not the whole pillow, is different, I submit that a logical explanation for the missing bedding is that likely they were saturated in blood after Gannon's murder and removed by Letecia to clean up the murder scene. Furthermore, investigators were unable to locate the bedding in the Stauch residence during any of the approximately 5 searches of the residence. They couldn't find it because they eventually found the suitcase with this bedding and Gannon's body in it. That is why. So they find the bedding whenever they find Gannon, some of it. Another photo was recovered from Letecia's cell phone that shows his bed was not pushed directly against the wall by the head of the bed. This photo articulates the ability for the blood to get onto the walls and the floor in the corner of the bedroom. Mr. Stauch stated that the positioning of the bed is unusual and that the bed is usually pushed against the wall. Mr. Stauch spent the night in Denver on January 25th. He flew out of Denver International Airport on January 26th. Investigators were able to corroborate that he did travel to Dallas, Texas, and ultimately to Oklahoma based on his flight records. On the morning of January 28th, Letecia rented a 2019 Kia Rio from an Avis car rent-a-center in Colorado Springs. Letecia picked up Mr. Stauch at the Colorado Springs airport at or about 8:50 on January 28th, shortly after Letecia rented the vehicle. Letecia and Mr. Stauch drove back to their residence from the airport in the rented Kia. The timing of the rented Kia is suspicious and combined with forensic evidence later obtained from the Tiguan and discussed below. It tends to place additional importance on why Letecia felt compelled to rent a vehicle that morning. Investigators located no evidence that the Tiguan was not mechanically functioning or noted any reason why it could not have been physically driven. In fact, the Tiguan remained parked in the Colorado Springs Airport short-term parking lot until approximately 7 p.m. on January 28th, 2020. She actually comes on Facebook and says, well, we had to rent a car so that Gannon wouldn't hide from us whenever we were driving around looking for him. You know, she didn't want him to be scared if she seen her vehicle. She also blamed it on the fact that she leased the Tiguan and she didn't want to put the extra miles on her vehicle. So that's part of why she rented it as well. So that's what she told the public, but it's obviously not what happened. She had to park it at the airport. She had to get a rental vehicle because she had Gannon's body in the trunk. And I think whenever Albert went to put his suitcase into the trunk of the car, he would have noticed that there was a bloody suitcase in the trunk of her Tiguan. She had to put a rubber sheet or something on that mattress to prevent it soaking through new bedding. That takes thought, and allowing the grandmother to sleep on it takes balls. OMG. I know. She let his grandmother sleep on his blood, on his mattress. Devastating. Okay. So she provided statements to her husband, Albert Stauch, that she was concerned about putting mileage on her Tiguan lease, which justified the vehicle rental. It is noted, however, that during the time of the Kia rental, Letecia only put about 71 miles total. The whole time she had that rental car that she didn't want to drive around her car to do all this searching that she was telling people she was out doing and that she was driving around the whole time, right? No, she only put 71 miles on the vehicle the entire time she had it. During the time period that she had the Kia, she would not provide the location of her Tiguan to Mr. Stauch, and he never saw the Tiguan. She wouldn't tell him where the car was. She had told him that she had left it near French Elementary School, which wasn't the case. She had it in the airport parking lot. So between investigators and Mr. Stauch, a limited search for the Tiguan was conducted and produced negative results. They didn't look very hard, though, considering that she left it just in like the parking lot at the airport. So investigators later learned she left the vehicle in the short-term parking lot of the Colorado Springs Airport, but removed the vehicle at or about January 28th at 7 p.m. The Kia Rio was returned the next morning of January 29th, 2022 or 2020. I submit that Letecia could not pick her husband up in the Volkswagen Tiguan because it would be likely that it would have revealed evidence of Gannon's murder, including blood or the actual remains of Gannon himself. So they pulled search warrants for the Kia Rio, and they took a swab of a stain that was in the blood of the trunk of the Kia Rio and submitted it. The DNA profile was developed and determined it was a mixture of two contributors, one which was male. The major male profile did not match Gannon Stauch's DNA. So whatever it was in that car, it wasn't from this, right? Investigators noted that the Kia had significant amount of mud underneath the vehicle, but did not provide any successful investigative leads into looking for Gannon's remains. Investigators collected the air filter from the vehicle and attempted to identify particles that might be useful to identify where the vehicle had been. Let me make sure. Hi, Boo Will. Yes, you got gifted a membership earlier by the Spudler. You are. She wanted back in that house really bad too. After she wasn't allowed to go back in, she probably wanted to clean up other stuff that she was hoping was missed, if I remember right. If I was that grandmother, she would not be in court today. I probably would be, right? Yes. Yeah. Whenever Landon and her mom showed up, they stayed there. Let me make that a little bit clearer. If I was the grandmother and my daughter-in-law did that to my daughter-in-law would be yes, and you would be the one on trial. I totally got it. I feel the same way though, honestly. She's just a monster. Honestly, she is a full-blown monster. There is no excuse for absolutely anything that she did to this child. There is no excuse for any of it. Period. You open this back up just in case they oh no. Okay. It's closed because they closed it. Okay. It's like, where did my WebEx go? It's because they actually closed the WebEx for while they were on break this time. Usually they leave it open and just keep it muted the whole time. Okay. So the Volkswagen Tiguan, they are saying, had significant evidence in it. It says the Volkswagen Tiguan is important to investigators because they believe the Tiguan was used to transport the remains of Gannon from the Stauch residence to the location where Gannon's body was dumped. The definitive locations of the Tiguan are unknown to investigators during the time period of 7:02 p.m. on January 28th until approximately 12 in the afternoon on January 29th. Investigators believe that Letecia dumped Gannon's remains on the evening of January 28th and utilized the Tiguan to do so. The Tiguan was seized from Letecia on January 29th. Letecia has scheduled an interview with investigators on January 29th at EEPSO, located in downtown Colorado Springs, Colorado. When she arrived at or about 12 p.m., she was driving the Volkswagen Tiguan. Investigators noted that the vehicle was wet and appeared to have recently been cleaned. I submit that Letecia had to clean the vehicle because there was likely visible blood on the rear end based on the below luminal reactions. Indeed, a video footage was recovered that shows a partial view of a car wash located at Pallet Avenue, Bonfoy Avenue in Colorado Springs, Colorado. This video captured a portion of a black SUV consistent with the VW Tiguan at or about 11:30 on January 29th at the car wash. The time and location are consistent with raw data obtained from the Tiguan's computer system, which was described more in detail on paragraph 152. Investigators applied and were granted the search warrant for the Tiguan, which was seized from T at her interview. They towed it to EPSO for evidence, and on or about February 1st, the evidence response team conducted a search of the Tiguan. In summary, the forensic portion of the search revealed possible traces of blood on the rear of the vehicle, a rear passenger seat, a front passenger seat, an area near the glove box. Based on luminol forensics latent blood stain reactant test, swabs from the trunk area were sent to the Metro Crime Laboratory for further analysis. These results reveal that a DNA profile could not be developed and that the swab from the trunk was negative for presumptive presence of blood. To be clear, luminol is a chemical used to detect trace amounts of blood at a crime scene. And although I do not have a chemical or biology background, I have learned that luminol reacts with iron and hemoglobin found in the blood. When applied, luminol emits a blue glow when the reaction occurs. I'm also aware that there are things other than blood that could cause a reaction, such as chemicals. I do not just submit that just because luminol reacted with a substance, that the substance must be blood, only that there is a strong probability of suspected blood. The positive reaction to luminol is meant to be combined with other facts in this affidavit in support of the probable cause. Several areas of the Tegon reacted to luminol. Specifically, the search team found evidence of suspected blood on the rear bumper, the step plate of the rear bumper, and the location of the blood is significant because the vehicle was backed into the garage at Letecia's residence the day of Gannon's murder. The search of the residence discussed below, but it is noted that the evidence of Gannon's blood based on DNA profile was also located on the floor of the garage, consistent with where the rear end of the Tegon would have been. The photo is included below to demonstrate the reaction of luminol. Blah, blah, blah. Yeah, it worked out too. You wanted her green, and there we go. Listening and cleaning. Seal, can you make a trip over and do my dishes? I have them in the sink, but we went to lunch earlier than I was expecting, and so they're still sitting there. Oh, you've been at work for 8 hours, still have 4 to go, so thank you for covering this. Thank you, Vanessa, for listening while you're working. Yeah, they were kicked out of the house as the landlord didn't renew the lease 30 days when your child is missing. Isn't that crazy? Mm. Oh my. Sorry, this is a lot of reading. I know that it's important to go through though because there's so many details in this. I just still don't understand how we're gonna fit DID into this somewhere. So they found the dollar store receipt and it was timestamped for 5:14 in the evening. The document of purchased trash bags, baking soda, vinegar, and items listed in paragraph 74. Investigators believe that Harley purchased these items at the direction of Letecia based on the following text message sent from T. Carpet powder, 2 things, baking soda, trash bags. Also included in this dollar store purchase was baby oil, baby lotion, cotton rounds, bubble gum. Investigators do not believe that these other items were involved in the cleaning of the murder scene and likely have no investigative value at this point. I know from personal experience that baking soda and vinegar are common household items that can be used to clean blood. Additionally, I conduct open source internet searches that revealed vinegar is one of the most common items used to clean blood stains, and that when baking soda is applied to the blood stains prior to the vinegar, it has an efficient effect in removing the stains. My thing is, so if law enforcement would have went to look under the bed, or if they would have thoroughly searched for him, would the floor have been wet? She cleaned up this massive blood stain, these massive um this huge cleanup project. Would the floor have been wet? And how did she get rid of the vinegar smell? Certainly, whenever Harley and Lena came in the house that day, it would have stunk to high heaven of vinegar. She probably used some already and needed more. Yeah, also the drains and the sinks, right. I don't know how she covered up this smell. I mean, because vinegar has a strong smell. I feel like if you go to search somebody's house because they're saying that their kid is missing and you walk in and there's like this like smell of vinegar, that's going to be a red flag. And so that could be part of where the time that it took law enforcement to respond, those extra hours because this wasn't important. He was just a runaway, could play a part in this taking a little bit longer to solve. Because was she able to mask the scent at that point with everything else? I don't know, Vanessa. I can't wait to see the body camera footage from this day. I really can't. So while the purchase of vinegar and baking soda are common, in no sense illegal on their own, the timing of the purchase with these items and Gannon's suspected murder are beyond coincidental. Also located was the parking receipt from the T-Gon being at the airport. And on January 29th, Letecia returned the Kia at approximately 9 a.m. She was picked up by someone driving the white Jetta. Investigators were unable to confirm that Harley was driving the Jetta, but it is her primary vehicle, and her historical cell site location from her cellular telephone records support that her phone was in that area. As such, I believe that Harley was likely driving the Jetta. Investigators were able to download telematics stored in the T-Gon for a more in-depth for a more in-depth exploitation of the T-Gon's electrical systems, and more specifically, its historical locations were developed and will be discussed below in more detail beginning in paragraph 152. Investigators were able to determine some of the locations of the T-Gon on the evening of January 28th, including its location in the area of Highway 105 South Perry Park Drive in Douglas County, Colorado. They also served a search warrant for her phone. And during that, it revealed that January 28th, between 8:30 and 10:20, the T-Gon was generally in the greater northwest portion of Colorado Springs, and also likely in the area of north of the Air Force Academy in southern Douglas County. I submit during this time period, investigators believe that Letecia disposed of Gannon's remains. And they get really in depth with this whenever we get down to these lower paragraphs. Even knowing whenever she put her phone on airplane mode and things like that, it gets super interesting to see what they're able to determine based on your vehicle and your phone movements, even if you think that it's not recording anything. So keep that in mind, you guys, if you're ever going to take someone out, they will find all the things. We actually found out during the Barry Morphew trial or hearing or whatever it was that they can see, like, when you roll down your windows, how many feet you back up and different things like that as well. It's kind of crazy what newer cars can do. So, of note, during the time period of 8:30 p.m. and 10:20 on January 28th, Harley's cell phone is connected to a tower that would service the Stauch residence. So, over approximately 30 miles from Letecia's suspected location. Harley was not with her, or at least her cell phone was not with her during the time that Letecia was disposing of Gannon's body the first time. There was activity on Harley's telephone during that time, and investigators do not believe that Harley was with Letecia when she disposed of the body. However, at approximately 10:26, Harley's cell phone leaves the Stauch residence and goes to the area of Powers and Carefree, where investigators suspect she picked Letecia up. So she told her to come get her after she disposed of the body. Yeah, kind of like Morphew, exactly. You love using vinegar and bleach or in baking soda. Yeah, they fizz when they mix. Baking soda can be used to help absorb the odor, but you're not sure it would eliminate it. See, I didn't think of that. Yeah, they break up proteins. DNA would be destroyed without bleach. Bleach is always a red flag to law enforcement. Yep. And Dawn. Okay. As mentioned above, Letecia voluntarily came into EPSO for an interview with investigators, but only after she was evasive and avoided speaking with investigators one-on-one. Her interview was audio and video recorded, and below information includes her own statements as well as investigation geared towards corroborating those statements. In general, her statements are reasonably categorized as untruthful, incomplete, misleading. Letecia was supposed to arrive at 10 a.m. on January 29th, but did not arrive until noon. Although she spoke with investigators on the phone several times, she did not want investigators coming to her home. It was difficult at best to track down. Investigators provided food and water to Letecia during the interview. Of interest, Letecia brought several pieces of notebook paper with her that contained notes that she had written down. During the interview, she referred to these pieces of paper and asked investigators if she should just read her notes. Investigators were not able to seize these documents. I have conducted hundreds of interviews of subjects, victims, and witnesses, and it's extremely rare for an individual to bring notes to an interview. Letecia drastically departed from her initial statements given to EPSO deputies regarding the disappearance of Gannon. In summary, Letecia had said she had been held at gunpoint and raped by a Hispanic male she knew is a Guardo, and that Gannon was abducted by the male after he finished raping her. The interviewing detectives believed that her statements were false based on prior experiences investigating sexual assault cases. Letecia said she arrived home at 2:30 on January 27th, 2020, and she disarmed her security system, went into the basement, and she said that A. Guardo was in the basement, attacked her, and pointed a gun at her. She said that after Eduardo held her at gunpoint, he allowed her to go upstairs, greet her stepdaughter Lena, and who had just arrived home from school. Letecia said she also sent her outside to ride her bike, then returned to the basement where Eduardo, continued to hurt her against her will between 3:30 and 4:30 in the afternoon. During this period, she believed that she hit her head and she may have blacked out. Investigators noted no injuries on Letecia's head during their contact with her. They also said during the attack that Gannon jumped on Eduardo's back and that Eduardo was able to throw Gannon off of his back across the room. After Eduardo had finished, he had the gun held to Gannon and demanded a suitcase. Letecia provided him with a brown suitcase and a cardboard box. Eduardo attempted to essay her again, but she hit her head and blacked out again. Letecia stated that she tried to fight Eduardo off but was unsuccessful. I know from training and experience that if an individual holds another person at gunpoint, he or she would likely not allow that person to have the opportunity for escape, as Letecia describes being allowed to greet her stepdaughter upstairs before returning to the basement. Most crucially, if Letecia's story was accurate, any reasonable person would have to immediately call 911 and reported a home invasion, a rape, and a kidnapping of their child. Letecia called law enforcement hours later and did not report the alleged rape until approximately 2 days later. Maybe it was her other personality that had all of these terrible things happen to her. Maybe it was Janelle or Taylor and not her, but she sure did show up for this interview and respond to all of their questions. Yeah, you need my pressure washer? Stop. Terrible. Wonder if Mr. Clean has anything to do with your relationships with the bald man or two. Oh my gosh, you guys are horrible. Yeah, you're surprised she didn't write a ransom note. Maybe she thought about it. Maybe she did. Yeah, it has John Benet Ramsey vibes to it. A little bit. Sorry, I have to get a drink and I have to stretch my mouth for a second. This has been a lot of talking today because I did that live this morning as well, where I was reading all those text messages. So I apologize, guys. Also for the fact that my voice keeps getting crackly and stuff at some points. So still not back from lunch. I just double checked. It is very hard work to talk for hours straight. I never thought I would ever say that in my life because I've always been the talker in my family, but it is very difficult to talk and talk and talk and talk. Okay, so where were we at? Of even more significance, Letecia said she had cleaned up the area where this alleged attack had happened. She straightened up signs of disturbances in Gannon's room, cleaned up the utility room. Investigators recovered cleaning supplies such as carpet brushes, which contained suspected carpet fibers. I submit that Letecia did in fact clean something up, but it was the murder scene of Gannon, not a sexual assault. Investigators took steps to corroborate Letecia's statements before dismissing them as false and misleading. For example, the investigators reviewed video footage from neighborhood security cameras that captured the exterior of the Stauch residence from the day of Gannon's murder and did not observe a Hispanic male entering the house. They did observe Lena arriving home on the school bus at around 3:11 and observed her enter the residence and observed her riding her bike at around 3:30. Furthermore, Letecia was offered the opportunity to have a SANE kit done, and she refused it. She said she did not want to have the exam completed. When given the opportunity to provide investigators with evidence that would possibly identify Eduardo, she refused to cooperate. Thank you so much, Vanessa. Yes, the elusive Eduardo, of course. Egg Guardo, I presume. Have any of you guys seen Egg Guardo? Let me pull up his picture. I got it. This was made by a jukebox whenever I was initially talking about this case way, way long ago. Where is it? Where you at, Eggman? Oh my goodness. I'm gonna get it. 1 second. Mr. Egg Guardo. She also blames a guy named Quincy Brown, who was actually who actually was a rapist, or he had similar charges to that anyways, and he was on the most wanted list. But she doesn't blame him until a week or so later. This was Eduardo, the jukebox maid, and of course he's holding a fork because that's how we prove we are who we said we are. Eduardo. It's similar to the McDonald case, the army. I'm not sure. Hi, Spencer Lineberry. Thank you for subscribing. Okay. So she stated that she met Eduardo on January 26th, the day prior to Gannon's murder. She generally described the Hispanic male with brown hair and brown eyes, but could not provide any specific identifying information. In summary, she told investigators that Gannon had knocked over a candle on Sunday, causing a carpet burn. After that incident, she said she drove around the neighborhood where residential construction was taking place, and she said she met Eduardo, who was working on a house, and asked if he would repair the carpet in her home. Eduardo agreed, and so she provided him with the garage door code, and they agreed that he would repair the carpet while she was shopping the next day. So she admits to leaving that night. I want people to remember that. She admits to leaving that evening after the candle incident. From what I had heard, very early on in the case, somebody put in the Facebook group that they were a neighbor across the street and that they didn't see anything strange on the 27th, but that she had left her home sometime, I want to say it was between 12 and 4, some time period between 12 at night and 4 a.m., and that they had video of it on their Ring doorbell camera, her leaving. And so they thought that, she had gotten rid of him in the middle of the night. And very shortly after this person had commented that and said that they had video footage and things of that nature, their comment disappeared and we never seen it again. And so I think investigators contacted them, asked them to take that out of the Facebook group and not to talk to anyone else about it ever again. I personally believe that's when Letecia went out and purchased street drugs or something along those lines so that she was able to give them to Gannon to try to plan the overdose theory when she was trying to figure out what the heck she was going to do because she hurt him however she did. Hi, Crime on the Record. Welcome. Thank you so much for joining us. They will be back in about a half hour back into court. So we're just going through the affidavit right now. They're still not back. I just double checked. They are not going after the death penalty, Holly Berry. No. Let me take that back down. Okay. So to the extent Letecia spoke about Lena, investigators were able to corroborate these statements, but never observed an Guardo or anyone else arrive or leave the residence during the time period based on the exterior video footage of the front of the Stauch residence. Specifically, exterior video footage revealed that Lena was riding her bike between 3:30 and 3:42. Furthermore, the front door of the residence opened and closed at 3:28 based on data from ADT security system discussed more below. I know from training and experience that when individuals concoct lies, the most reasonably or most reasonable, the most reasonably to conceal the truth, they oftentimes leave portions of truth within those lies. And boy, oh boy, has T made it a point to always do that. She always is sprinkling truths within her lies. I submit that statements Letecia made referencing Lena and the time period Lena was at the residence are likely true based on video evidence. Her other statements, however, are blatant lies designed to mislead investigators. Investigators also reviewed Letecia's phone records during the time period of the alleged rape, 3:30 to 4:30 p.m. on January 27th. During this time period, Letecia had phone activity to include outgoing phone call, numerous iMessages to Mr. Stauch and Harley, namely to discuss purchasing a new set of headphones for Albert. Again, where does DID fit in with this? How are they proving that she has DID whenever she had all of these conversations directly after that are normal, just talking about buying headphones? Or is this where they're going to say that she dissociated from what she did to Gannon and her alternative personality took over and was living its normal life, having these conversations while her other half of her was in a panic and cleaning up this mess? Is it possible that the event of killing Gannon did send her into some type of identity disorder? But that would be the act of doing it, right? That would affect the cleanup, the events after, not the actual event of murdering him, because there would be no trauma prior to that, right? I mean, I don't know. That's just my thoughts on the whole situation. And they no longer have the death penalty. Have we ever heard mention before about her having DID? Um, like, no. Not until they started trying to prove her insanity defense. She's been through literally, I think it was what, 5 total competency evaluations or evaluations, I guess I should say. Only 3 of them were competency, I think. I have to look that up. But nobody has ever mentioned DID before through all of this. And so it's just this one doctor. The part of her with a conscience has been compartmentalized, in my opinion. Yeah, Spudler. And that's the thing though. So her doing this, the actual act of murdering him, was her. Could she have split into separate personalities afterwards? Absolutely. A traumatic event can spark something like that. But she did this. she did this. As a therapist, you don't see anything so far that would speak to DID. Right. It's mind-blowing, but I gotta pull this up again because I can never remember her name. Dr. Dorothy Lewis is who she is having um do this. And she is saying, as of yesterday, we heard that she did in fact find her to be insane at the time of the murder. So it's going to be extremely interesting to see what her evaluation shows and why exactly she's saying that. Yeah, dissociating doesn't equate having DID. Yep. She had read all the books by the time that, yep, I agree with that. The Smuggler. She had 2 years to read books prior to going to see this lady. Exactly, Connie, and it was all premeditated. She planned all of this as she was leading up to killing him. It's just crazy. Mm. Okay, so the Stauch residence was equipped with basement and living room motion detectors and contact detectors on the front and rear of the door. ADT was in possession of logs that documented the time, date, and type of event that generated a log. For example, when either motion detector was activated or the front or rear door opened or closed, there is a record of that event. Letecia claimed that she was raped in the basement between 2:30 and 3:30. Up above it said 3:30 and 4:30. So I think they might have messed that part up because right here it says alleged rape 3:30 to 4:30, and down here it's saying 2:30 to 5 or 3:30. So I guess no, because she said that she was interrupted by Lena coming home. He let her go back upstairs and then she continued to harm her. So I guess it was the entire time period, right? So during that time, the back door of the residence located on the main level was opened and closed 10 times. If indeed Letecia was being raped in the basement, it would be impossible for her to open and close the back door of the residence at the same time. I submit that Leticia's claims of being raped in the basement are false based on her cell phone activity and stored ADT data. The logs from ADT indicate significant activity in the basement of the residence where evidence suggests that Gannon was murdered. For example, between January 23rd and January 26th, the hours of 3 until 5, the average number of basement movements was 3.5. On January 27th, the average number of basement movements was 10.3. A possible scenario for this increased activity is that Letecia was going up and down stairs in order to get cleaning supplies and cleaning up the murder scene. Towards the end of the interview, Letecia said she wanted to leave. Investigators seized her telephone and detained her while they applied for a search warrant to obtain DNA collection. Letecia began stuffing tissues in her pants and saying she was having chest pains and shortness of breath. Investigators immediately requested medical assistance, and paramedics from the Colorado Springs Fire Department arrived. Letecia had the appropriate responses to the paramedics' questions. This is going to be huge because she was answering their questions about who she was, her age, all of that stuff. I guarantee you that's the type of stuff that they're asking. And she had appropriate responses to that. So there, it was not somebody else. It was not a different personality that was having this event. It was not a different personality that was talking to these investigators. It was her. She answered the paramedics' questions fine. Says, I am aware that Letecia has made statements regarding Gannon's disappearance to individuals other than law enforcement, including but not limited to her friend, her husband, and the media. Indeed, some of these conversations have been captured and memorialized in recorded phone conversations, email messages. Leticia's stories have continued to evolve, and the matter of facts continue to change, including but not limited to the identity of her attacker, the location of Gannon's abduction, and the details of the alleged rape. During her statements, Letecia did deny killing Gannon and provided explanations as to why there was her blood in her tea gone, blood in Gannon's room, and why she was in the area of Palmer Lake, Colorado. Go back. Sorry. Your friend had to watch her. Oh, wow. Retract. That's crazy. At the hospital in Pueblo. Yes, it is definitely the woman that you were thinking of, crime on the record. She is obsessed with people having DID. Of course, they had to get her to get the diagnosis they wanted. Exactly. There was multiple other psychologists that seen Letecia, and no one ever diagnosed her with this. And now all of a sudden they got this one. And granted, they waited until the very last minute to give the prosecution the information, to give them her report. And so I don't know how much that's going to play into getting somebody to come in, a professional to come in and debate what this woman is saying about Letecia. I really hope that it doesn't negatively affect their ability to respond efficiently. But I think we all kind of knew that this was the diagnosis that they were going to try to get and go with. Is there anyone supporting this woman? Not here personally on her side. So in the beginning, I think that a lot of her friends and family wanted to believe that what she was saying was true. No one wanted to believe that what she did to Gannon happened. Okay, here we are. Let me see if they're talking yet. No, they're still muted. Okay, but they are back to where I can hear it whenever they start, which is good. So in the beginning, her family wanted to support her, right? She had a friend who she was staying with in North Carolina. And obviously, I think Harley and people like that, they wanted to support her and believe that what she was saying was true, that she didn't hurt Gannon, that she didn't harm her. And once Gannon's remains were found, even the Letecia Stauch support group on Facebook all turned on her. And I have not seen any support from her friends or her family since Vocally Out Loud, since his remains were found. Because I think at that point, how could they deny what happened? So, and if somebody was out there supporting her, I don't know about them, if that makes sense. Okay. So she was transported to the hospital via ambulance from EPSO for further medical attention. She was accompanied by detectives during the ride to the hospital. Unlike questions at EPSO by paramedics during the ambulance ride, Letecia was unresponsive to questions by medical personnel and seemed to have a miraculous recovery when they arrived at the hospital. The ambulance ride was audio recorded. Letecia received medical care at the hospital, and details of that care is not included in this affidavit for medical privacy reasons. Letecia did not have any life-threatening issues and signed herself out prior to all of her exams being completed. She checked out as soon as she possibly could. Letecia continued evasive behavior at the hospital, but particularly after investigators told her they were going to detain her pending the issuance of a search warrant to collect her DNA. Ultimately, the search warrant for the collection of non-testimonial evidence was signed and executed. A second warrant for the complete SANE exam was initially authorized by this court, but then was quashed by the court. To be clear, Letecia did not allow a SANE exam to be completed. 1 second. I'm going to check this. Okay. Letecia was not in custody after the warrant was executed at the hospital and left the hospital without telling investigators. She also made a phone call from the waiting room at the hospital. There was physical surveillance being conducted by law enforcement in the area, and investigators learned that Letecia was picked up by an unknown person at the hospital and was reunited with her daughter several miles from the hospital. Although her behavior was not illegal, I submit that as pressure continued to increase from investigators, Letecia became more and more desperate to leave the hospital, likely because she feared being caught in her lies. Furthermore, Letecia did not want to pursue collecting evidence that might assist law enforcement in identifying and finding her supposed rapist. So then they have the searches of Letecia's residence and the discovery of confirmed blood in Gannon's bedroom. Yeah, you wonder what T's mother is thinking. Me too. Investigators searched the Stauch Stauch residence several times over several weeks after applying for and being granted search warrants from this court. The purpose of these search warrants was to collect evidence, including biological evidence, in support of the captioned investigation. The forensic searches were conducted by Colorado Springs Metro Crime Lab to avoid the confusion. The January 28th, 2020 initial search was authorized by Mr. Stauch. He provided consent to search the residence. Not all of the evidence recovered is included below. However, the forensic testing results of several items, including a pair of 8.5 Nike shoes, are discussed in paragraph 126. Gannon's remaining family members were living in the residence. Oh, here we go. Oh, maybe they were just testing. They definitely came on though. Let me switch how I'm sharing screen. That way, whenever they do come back, we can hear it. Okay, so Gannon's remaining family members were living in the residence during the period of these searches, and investigators did not initially seal the residence off. Crime scene analysis from Colorado Springs Metro Crime Lab responded to the residence and found traces of blood throughout the residence based on Blue Star Forensics latent blood stain reagent test. There was visible blood on Gannon's room, in the garage, and other portions of the house. By the way of background, the residence located at 6627 Mandan Drive, Colorado Springs, Colorado, is a ranch-style single-family home, approximately 2,500 square feet with a 2-car attached garage. There are 4 bedrooms and 3 bedrooms in the residence. 2 of those bedrooms are in the basement, including Gannon's. Next to Gannon's room, there is an unfinished utility room, and on the other side of the basement, another bedroom and a bathroom. There is a staircase with a small landing that allows access from the main level to the basement, and the garage is accessible from inside of the residence. And actually, guys, I will get the walkthrough of the house pulled up because we do have one of those somewhere. I just got to find it. And that way you guys can see what the inside of the house looks like, because it makes it a little bit easier to visualize like what happened, I think.
They don't have to.
Okay. So the Blue Star reagent was applied to Gannon's bedroom and the hallway leading to the utility room from his bedroom. The utility room itself, the stairs, the landing leading upstairs from the utility room, the pathway to the garage from the stairs, and the garage itself. In all of those areas, all of them. So we're talking the hallway, his bedroom, the utility room, the staircase, the landing, the garage, the stairs, like all of it, all of them, they found blood. That is a lot of blood, you guys. Specifically in Gannon's bedroom, in the corner of the room, investigators located an area where suspected blood had seeped through the carpet, through the pad, and stained the concrete. Furthermore, there was also blood stain and projected blood spatter located on the walls in this area. Indeed, over 50 droplets of blood were found on the walls near his bed. Crime scene investigators also suspected that someone attempted to clean the walls based on the way the Blue Star reagent reacted to the wall. Gannon's mattress was also seized and contains red stains consistent with blood
Right,
in the
court will
same
call,
area.
Court will call 20 CR 1358
Here we
People
are.
versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. When we took our break this morning, I said that when we resumed, we would be restarting with questioning by the attorneys. That's where we will start at this point in time. Prosecution.
Somehow they always make the prosecution go first right after lunch, and everybody's tired, right? Let's get some ground rules, talk about those before I get into the meat and potatoes discussion. this is a safe space. Everything that we talked about here is to determine and help us figure out who would be good jurors for this case. It's not a personal condemnation at all. If you don't make it onto this jury, it just means that this particular case is maybe not the best case for you. But we're confident, based on the way that we've seen the jury system work, that we can get fair, unbiased jurors through this process of this questioning. The way that that works the best, though, is hearing from all of you. So it doesn't do us any good if it's just me talking the whole time. So I'm going to be making sure I touch as many of you as I can with questions, not physically, but with questions. You got my joke. And really hoping to get some really good discussion going on some of these different topics. So with that in mind, does everybody agree to that? That if you have a thought, please raise your hand. If you don't say your juror number, I'll try to say your juror number. Again, that part's actually awkward for us. We're usually used to using names when we do this, using your last name. But trying really hard to be very cognizant of the concerns as it relates to this particular case, just using juror numbers. So if I don't say it, please help me remember to say your juror number. So with that in mind, I would like to have somebody give us what comes into their head when they hear me talk about what Lady Justice looks like. What do you think about when you think of Lady Justice? Okay, so someone over here, I believe number 17. Well, seat number. Yeah, I think you said. Yeah, so that's the other thing we like to do is confuse the heck out of all of you. Pull you out of your comfortable lives and make you sit in cramped corners and get to know your neighbors really well. 17, you said scales, I believe. What do the scales mean to you? Equal rights?
Justice.
Okay. Equal justice? Okay. Any other thoughts about Lady Justice? Okay. We have, I believe, number 33. Thank you. Yep.
I remember it, she's wearing a blindfold.
Okay.
So whatever's in her hand.
Okay. Sword also. Do you remember the sword? Okay. Now it's coming back to you. But it's interesting that you said the blindfold. What does that blindfold mean to you or to anybody else?
She's no respecter of persons. She's only looking what the evidence is.
You're saying it exactly right. And I'm going to add another wrinkle to that. What that blindfold represents is that the justice system should be fair and impartial, the themes that you're hitting on. The scales are to weigh out the facts in the law and determine whether somebody did something that, like we're saying, this defendant did something. And that blindfold represents what you all have to come into this process with, being fair and impartial so that we can have a due process right that every American is entitled to under the US Constitution. So does everybody here agree that you will be open-minded, listen to the facts, and then base any verdict that you come to in this case based on that kind of a mindset? If you agree with that, please raise your hand. There's some people that are not raising their hands, and I'm going to call on those folks. So number 13, you did not raise your hand.
Yes, there's just been so much coverage that you almost feel you got your mind already judgment determined.
Okay.
And I mean, your opening statement.
Yeah.
It was like, turn on the TV and watch the evening news. It's like,
Okay.
yeah,
Okay.
you know.
So let's talk about this concept, Mr. 13. The stuff that you see in the media, do you think that the media, and I'm not casting aspersions, but do you think the media reports all the facts?
No.
Do you think they report the facts accurately?
No.
Okay. And so with that in mind, do you think that you can set aside what you've heard in the media because it's not the full story? And in fact, it's not evidence in this case. Do you think you could set that aside?
Yeah. It'll be difficult, but you know, it's something you gotta do.
But you think you could do it? Okay. What about juror 14? I think you did not raise your hand either.
But you just stated about Lady Justice and being fair.
Yeah.
I have real strong negative feelings about the whole judicial system.
Okay.
I don't believe in it. I've known firsthand, I've seen a lot of unfairness and discrimination,
Okay.
and that goes from the judge to the DA to the law enforcement to everything.
Okay.
So I do have very bitter feelings about the whole judicial system. I think it's messed up and
Okay.
it needs a lot of work.
Okay. So let me ask you this then, with that experience in mind and the things that you just expressed, which are totally valid, you can have those opinions. Do you think that you can set that aside and judge this case based on what happened in this courtroom or not?
You know, to be honest, I'm just so bitter because what I've experienced through this court system, I really don't think so.
Okay. And so that's based on your own personal experiences? Okay. Thank you for saying that. Number two, I think you also did not raise your hand when I was asking you.
I missed it, I'm sorry.
Oh, that's okay. So when I was asking about, can we all agree that we're gonna be open-minded and be fair and unbiased in this process? Do you agree that you can do that? Yes. You do agree. Okay, thank you. Number four, what about you, sir?
No, yes.
You do? Okay. And I believe you are an engineer in the Navy, is that right? Okay. You have to say yes or no, otherwise. she
Oh,
may
yes.
put you down.
Yes, I am an engineer in the Navy.
And by the way, if anybody messes that up, I'll be the one that gets in trouble, not you guys. I've already given her permission to throw stuff at me. Does 1 + 1 always equal 2?
Yes.
Okay. What if there's a negative integer? Can that be
0.
Okay. So is that kind of a way of thinking about, there could be two different perspectives about something that may seem obvious to people?
Yeah, absolutely.
And what are your thoughts about that? How do you think that might apply to what we're going to do here?
No,
You're gonna hear witnesses
Yep.
that come in and give you descriptions about what they saw, what they heard, what they did in this case. And then you might hear another witness, maybe from even the defense side, that comes in and says something totally opposite of that. How do you reconcile those things?
I think if it was two credible witnesses, they both raise their right hand and tell you two completely opposite things, I think they cancel each other out.
You think they cancel each other?
Yep.
Okay. Everybody hear what Mr. Number 4 said? That's so weird to say Mr. Number 4. Everybody hear what Mr. Number 4 said about that? Anybody have any disagreement with what he said? Not seeing any hands. What about number 6? How are you doing so far?
I mean, I feel like my previous statement may have been sufficient. Just in given what I already know about this case and what is being defended. At the end of the day, I feel like my mind is made up. I don't believe that there's any evidence. So,
Okay. You haven't had any evidence yet, correct? Although what you've heard in the media, which you talked about earlier. Again, yes, a yes or no.
yes,
Okay. If you are on, let's assume that you're on the jury right now, and you haven't heard any evidence. With what you have in your mind, how would you have to vote? Guilty or not guilty?
I don't know the answer. Given what has already been said by you earlier about what we're gonna see, what we're gonna be shown.
Okay, so here's what I'm getting at is that the prosecution, so as the district attorney and every DA in my office, that's a deputy DA, we have the burden of proof. If we don't prove a case, then you have to vote not guilty. So if as you're sitting here today, you haven't heard any evidence. So if we said, okay, now you gotta give us a verdict, what would your verdict have to be under that guideline?
Prior to.
Okay. And so if we don't satisfy our burden of proof, so we don't give you enough evidence to prove that the defendant committed the crime that I talked about earlier, would you feel comfortable setting aside what you heard in the media and voting not guilty? You wouldn't. Okay. anybody agree with, Mr. number 6? Okay, I see a head nodding and you are number, I'm not sure what number you are actually. You're 40, okay. So you all spread out a little.
Have to say not good,
You were saying that he would have to say not guilty.
just agree.
Okay, and are you comfortable with that holding us to our burden? We're gonna come back at the very end of this, after all the evidence has been presented, and we're going to say, we expect the jury to hold us to our burden. But if we have satisfied our burden, we're gonna ask for the jurors to find the defendant guilty. Are you comfortable with that process?
Yeah.
Okay. Part of what we have to do as prosecutors is present evidence. So every single bit of evidence that we're going to have the jury consider in this case is going to come from this witness stand up here. So people will get on the stand and they'll testify, they'll take an oath. You'll see pictures, you'll probably see videos, you might hear audio recordings. Including some of those pictures are going to be some really horrible things. You're going to see a decomposed 11-year-old boy who has suffered horrific injuries. Do you think, as you sit here, that you can do that? Look at those things and consider whether the defendant is guilty or not guilty based on what we're presenting. And I see Mr. 55 is shaking your head. I think no. Correct. So tell me what's going through your mind. Okay. Okay. That's a different topic that I want to touch on. I'll tell you a story. Several years back, I was doing a different murder case prosecution. One of the people that was in this type of a group had previously worked in the coroner's office. But only worked there for a short amount of time. We're asking him questions about could he do this job and see those types of pictures. And then he ends up on the jury and we get to the autopsy pictures and they can be shocking. I mean, if you're not used to seeing that kind of thing. And he immediately shot up out of the seat and had to run to the bathroom. Lost his soil. Basically. So that's the kind of thing that you're going to have to do if you end up on this jury. And so it's good that you let us know that. If you don't tell us those things, then it's going to be a difficulty for you, then we don't know it, right? And so let me go here to the front. 24, thank you.
I think I'll personally have a problem like stomaching it. Normal circumstances, I might be able, but I have on the way.
So I'll tell you another personal story about that. When I was in law school, we had at the school that I went to, the Defender Project, whereas after your first year, your second year of studies, you could do the Defender Project, and I did that. And I had young kids, they were 2 and 5, I think, at the time, 2 and 6. And one of the cases I got assigned to was a young child death case. And it was hard because it was personal. It made it seem personal. And so you're saying that might be difficult for you because of that personal connection? Anybody else feel similar to that? Yeah, let me get your number. Thank you, sir, 35.
Yeah, I kind of feel the same way because I have a friend.
How long ago was that?
About 10 years ago.
Was it here or somewhere else?
Something.
Okay. You think with that experience in mind that you could work hard to set that aside and just judge this case based on the evidence in this case?
Probably could, yeah.
Probably could, okay. And going back to you, number 24. You're expressing some reservations about whether that would be something you could do or not. You think you can judge this case based on this evidence and put that personal side to the side and judge this case just on the evidence?
I don't think you would affect my judgment on the case. Thank you, stuff.
Okay, okay. Any other thoughts on that before I move on? Yes, thank you. You said 30, 36? Yeah, 35 over there. Yeah. And that's a personal thing. You're already sort of answering your own thought as you're saying it, knowing that if you see something that's shocking to you, it's probably going to stay with you for a while. I can tell you the first murder scene that I went out to, and we go out to murder scenes with the police officers, I still remember about that. Very good at things, smells, images. And so you have to work through them in your own personal way. There's no magic way to get past that. But it is a consideration you'll have to think about. How do you as a person in everyday life, because we do this every single day, we hear stories from people and we're able to reconcile two different viewpoints, kind of like what I was talking about over here, two different viewpoints about a singular event. Maybe two people go to the same party, they have different experiences, they describe the party differently. Doesn't mean the party didn't happen, right? It's just their own different perspectives. How do you judge somebody's credibility in that scenario? '29. You've been quiet today. Okay. Have you ever had two friends tell you about something and then you listen to them and you think, oh, this guy is full of baloney, this guy's not? How did you do that?
You're 29. Can
Yes.
you speak up a little louder so that we can hear you better, please?
Yeah. So basically, he was saying that he would listen to both sides and try to figure out which one was telling more true things, basically. I'm paraphrasing. Is that a good paraphrase? Okay. Again, speak up. Here's a funny thing, and I know right where you are. You're a shy person, it seems like. In school, I'm still actually a very shy person. I used to really hate talking in front of people. And so when we had those assignments where we had to give a presentation to the class, I would hide in the back, slink down in my chair, get sweaty palms, not want to get called on. And then I'd finally get up there and I'd fumble my way through it. So of course I become a trial, right? So I know exactly where you're coming from, but again, to help us flesh out who's going to be good jurors for this case, we got to get into some of those topics. Okay, so my apologies for calling you out like that, but we just have to have those things happen. Yes, ma'am. And you are 37, I believe? Or are you going to be 35 too?
I guess just get her respond to the question. Teenagers. Stick the way it is. So
Are you able to work through that and figure out what happened?
yes, I mean, the thing is,
How do you determine somebody's intent, what they intended to do? Without getting into whether they said they intended to do something. Do you think of any experiences where you have to figure out somebody's intent? Okay. And you are, again, I believe, 17, thank you. You get a feeling? Okay, all right. So yes, ma'am. Not 35, 38. That whole row is now 35.
in my line of work, intent is, I learned a lot about past.
I don't know what SMI is.
Seriously mentally ill.
Okay,
So I use SMI for the state of Arizona. see a lot of people that come with prices.
Okay. So let me try to see if I'm understanding what you're saying, just so we're all on the same page. You look at their actions to see if they follow through with,
Before they even got to this point, what was their past history? I've done habitually in the past, and now here they are in front of me. I'm kind of like a pre-judge, and then they go.
so. Are you saying actions can sometimes be louder than words?
Yes.
Okay. Anybody agree with 38? Anybody disagree with 38? Number 19, you raised your hand really quick. And I asked you, right, did you take a break? You raised your hand really quick when I said anybody agree with what, actions speak louder than words. Why was it so quick? What was in your mind? Actions always speak louder than words. Okay. Anybody disagree with 19? Seeing no hands. So let's do this. This is gonna be a really silly example. Let's say that it's illegal to buy more than 1 pound of ground beef at the store and get it. And I go in the store and I buy my 1 pound of ground beef. And I go out to the car and then I come right back in and I buy another pound of ground beef. I do that like 4 or 5 times. Am I exhibiting an intent there? Number 21. What about, yeah, so what about that description tells you I knew that it was illegal? Okay, so. Again, is that an example of action speaking louder than words? Anybody disagree with that idea? 36. Okay.
The one. That was similar during COVID, right? Let's be honest, right?
Yeah. That might be an excuse. Anybody have thoughts on what 36 just said? No?
I think it's right.
You don't think what's right?
Greedy.
Okay,
Because you're hurting someone else.
so you would convict me for buying too many pounds of ground beef under that scenario? And it's okay, the answer is yes. Judge talked about recipes earlier, recipes to likening it to what we have to prove in a criminal case, the elements of a crime, and he used the Denver omelet idea. That's similar to what we do in criminal law, where a particular crime has elements that we have to prove. What we have to prove as prosecutors is only those elements beyond a reasonable doubt. All the side stuff, we don't have to prove. Who here thinks motive is one of those things we have to prove to achieve our burden of proof? Motive. Okay, and again, number 17. You think motive helps?
Sure.
Okay. If you're on this jury, do we have to prove motive to you to satisfy our burden of proof?
Everything else has to get there.
Okay, all right.
Mr. Allen,
Yes,
thought you had a hand
Oh,
for number 4.
Yeah, yes, I mean,
thank you.
you have to meet all the burden of the charge.
if that's one of them, then you have to meet that.
Okay.
But, you know, you're just driving down the road and you took your eye off the wheel and you ran somebody over and killed them. There's no motive there. But you don't charge them with that. You know what I mean?
Yes.
So that's important. That's an important piece of it.
It might be a good way of understanding why something happens, right, is what you're describing. And I think that's the human condition, that when we hear of something happening, we want to know why something happened. Does everybody agree with that? Does anybody disagree with that? As humans, we want to know why something happens. Here's maybe an eye-opening thing for everybody. Motive ain't one of those ingredients in the recipe for the crimes that we have charged in this case. We don't have to prove motive. It's not one of the elements, not one of the ingredients for that Denver omelet that the judge was talking about. Anybody have any thoughts on that? Anybody have any issues with it? Or does it make perfect sense to you? I'm gonna call on, I've been meaning to get to you, number 34.
No, that's good to know, but that's not part of the, I think of religious. I was thinking back, I would go back to the. Oh, no. Why you can do something. You may. That's what comes around me.
You're good with that. Okay. And I think you were one of the people that had mentioned, I think you agreed with one of the other jurors earlier this morning about having heard some stuff about the case and then sort of wanted to retract what you put on your questionnaire.
Right, yeah, I did, just explain that. Sure, but hearing stuff in the news, I can work down in that. After going through the process, let's see what it. Frustration of.
Lady Justice.
Yes.
Yeah.
Right. Really helps me with that. Why did it explain that?
So with your experiences in mind, having worked in that area, having seen some news, having put the things down that you did on your questionnaire, do you feel like you can be a fair and impartial juror in this case and just judge the charges against this defendant based on what happens here in this court?
No doubt.
Yeah, no doubt that you could do it. Okay. Does anybody, we already heard from number 14, and I think number 13 as well, kind of feel the same way. Anybody else feel differently than what 34 just said? Anybody feel like they can't be fair and impartial during this case based on things that you might have heard or seen in the media? Okay, yep. Number 6 is raising your hand, and based on the stuff we talked about earlier.
I would like to mention that I feel like I've learned more about this case in the few hours I've been in this room than from the media.
From what's happened here.
Yes.
Okay, so that gets to the concept that the judge mentioned earlier that the only people that can give us evidence in a case come from that stand. So we're not witnesses in the case. So myself and the other 2 attorneys from the prosecution and Mr. Tweeney and Mr. Cook are also not witnesses. So the things we say is not actually evidence. What do you think about that? Does that change your opinion as to can't consider necessarily what we say as you weigh guilt or not guilt?
I understand that what has been presented this morning is not evidence, but it was said that what you had said was true. Before this being in here, there was very limited knowledge I had of this case. I knew a boy had died. I knew who the accused was. I knew he was found in Florida. Since then, I have learned that he was stabbed multiple times, defended himself, was shot, was beaten, was driven to another state to be disposed of, and all of that stuff. And then I was told that everything that you had said was true. And that the reason we're here is because they want to convince us that she was legally insane. at the time of committing these acts that we've already been told happened and were true, you know, without a shadow of a doubt that this boy is dead. I can't see myself looking at this any differently than the drunk driver killing a family.
Okay.
Whether or not they remember it, they were sound-minded when they did it, it doesn't matter, they still did it.
Okay. So let me clear up, one thing that you said, as it relates to the law, what it says about this process. We have to prove that, everything, all the elements for the charges that we've charged here, all the counts, we have to prove those elements beyond a reasonable doubt to whoever ends up on this jury. We also have to prove, or you could say disprove, prove that the defendant was sane at the time of committing those offenses. This table here, the defense table, doesn't have to prove anything to anybody. And that's based on our constitutional provisions that are unique to this United States. No other country in the world has those same provisions in the law or allows defendants to have the rights that they have here in the United States. Does everybody understand that as it relates to who has to prove things and who doesn't have to do anything? Does anybody think anything differently about that? That they think they want the defense to prove something to them? Not seeing any hands. Okay.
Yeah,
Yes.
this is probably the thing that I'm struggling with the most.
Okay.
So if everybody sitting there agrees that this happened, including the defense, but they have a defense, isn't that implied that they have to prove that she wasn't in sound mind when this happened?
So the answer is no, they don't have to prove a single thing. They raise the defense, it's called an affirmative defense. And then we have to disprove it. So let's use this as an example to talk about this particular point. If, say there's a bar fight where one guy punches somebody else at the bar, and it causes that person that gets punched to have a broken facial bone or something like that, that would be a felony offense. But maybe the person that threw the punch says, yeah, I threw that punch because the other guy pulled a gun on me, so I punched him before he could shoot me. So raising the affirmative defense of self-defense. So we would have to prove in that scenario, one, that the person that punched actually punched and caused that broken bone. But we also have to disprove that it was self-defense. Does that make sense? I heard it over here, so yeah. But does that make sense to you, number four?
It does make sense, but what I'm laying out is I'm just kind of struggling with this concept.
Yeah. And I think it's a reasonable concept to struggle with. If you haven't gone through this process before, it sounds odd that they don't have to do anything, right? They can just sit there. I know that they're not going to do this. They're really good trial attorneys, but they could sit here and not say a single word for the entirety of the case. And if we don't meet our burden, you have to say not guilty, even if they don't do anything. You don't have to prove a single thing.
You've met your burden.
If we meet our burden, then you can vote guilty. If we haven't met our burden, we have to vote not guilty.
I guess what I'm getting at is if all the evidence points toward meeting your burden, then if the other side says nothing, why would anybody hear vote the other way?
Okay. And really what you're saying is that you're assuming that we have met our burden in this hypothetical scenario.
Right.
And then you're absolutely right. If we've met our burden and the jury feels that we've met our burden, the right verdict would be to be not guilty if we've satisfied our burden. So you're hitting on exactly the right thing. It's just struggling, I think, in talking about these concepts that you don't have to deal with every day like we do. But you're talking about the law exactly the right way, just in not the way we talk about it. Does that make sense? And so I heard somebody back here say yes or uh-huh.
Sense of insanity. I see.
And you're 30,
38.
38.
So I've seen this open person around the store. I've seen it. Because I deal with that type of population. So I think you not. So I think that would be clearer for him to But, I'm just talking.
Yeah,
Like,
yeah.
if we were together, that it is possible. I, you know,
And so actually, we're gonna jump into some of that. I was gonna do this anyway, but you're bringing it up now. So you have that history on working with mental health patients,
Yeah.
right? Would you agree or disagree that there's a wide spectrum of mental health? Lots of people with mental health are still sane,
oh, yes.
know what they're doing? That's a yes or no.
Oh, yes,
Yeah.
yes.
And can form intents,
Yeah.
intentional with their actions. And getting back to what you said earlier, their actions can speak louder than what they're saying with their mouth.
Yeah.
With your background in mind, do you think that this type of case would be good for you or not? Good for you? Okay.
I believe I know both sides. All studies for mental health, correction, in-person outpatient, excuse me, crisis. And I see both sides, I see people that. I know nothing about this case.
Perfect, sure.
Yeah, I was like, I know nothing. But just.
Anybody hearing 38 say that, have any opinions that they want to share? Oh, you had your hand up for a second. Yours. Anybody else? Back here, number 2, thank you.
Number 4 brought up the issue of, what do you have to prove? If the defense is not guilty because of insanity, who has to address the sanity issue?
Okay.
Is that part of your element?
So that's something that we have to disprove. Yes, so we have to prove that she was sane at the time of the offense. So let's talk about that for a second, and I want to come back to 35, 36, 38. Come back to you in just a second. The insanity part only applies to at the time of the offense. Meaning that we have to prove that she was sane on January 27th, 2020. If she became insane later than that, that's not, has nothing to do with this case. If she was insane before that, but then got better, has nothing to do with this case. Does that make sense with what you're saying, sir?
But you have to address it,
We will have to address it, and we will address it.
because you said they could do nothing. If they do nothing and claim not guilty because of insanity, then there's no evidence.
That when they claim that, then we automatically have to do some things to disprove it, okay? I'll get to you in just a second, okay? What are your thoughts about what I just said? It's at the time of the offense, not other times, that matter.
Typically in my. Trauma, severe trauma, that's what I mean, background is very important. That's gone crazy. That's right there. Plus, there was something that triggered her.
Five minutes, Mr. Allen.
So they just, not that they can't. Seen some.
Okay.
Or.
We are going to have doctors testifying on both sides of this case in more likelihood. And part of our jobs as prosecutors and part of their jobs as defense attorneys is to cross-examine those witnesses. You may see some of those witnesses get challenged pretty heavily, and maybe very strenuously and maybe, animatedly even. What do you think about that? Do you think having maybe their doctor or our doctor really get raked across the coals, part of this fair process? Is everybody good with that? Watching that sort of thing happen? Yeah, okay. Number 73, way in the back. We know each other from political circle, right? Despite the fact that we know each other, you think, you can set our, friendship aside and, just judge this case based on the evidence that you might hear in this case? Mr. 66, you put down, I think, maybe some hardship because of work stuff and representing Teller County. You have to tell us whether you have the time to serve on this jury or you end up. I'm about out of time. The judge, as lawyer, we want to get up here and talk for 2 hours, but he won't let us for some reason. Is there anything gnawing in the back of your mind saying, I wish Michael would have asked us this, that, or the other thing? Because it's important that they know this about me or my viewpoints. Anything like that that you want us to know about right now? Yes, number 55. Okay. Okay, thank you. If you couldn't hear, do you hear it? Anybody else have anything? Yes, ma'am. We have
Number 33.
33, thank you.
Sorry. I just want to say, I don't want to see awful pictures and but I am so passionate about this country's children. It feels weird to sit here and hope that I might be able to do all this. Such an important.
That's one of the things you marked on your questionnaire was that you had seen some stuff and then you realized the story was too sad for you, so you avoided it after that. Do you think you could be a good, fair, and impartial juror in this case if you're in a public jury? Okay, thank you, Judge.
Right. I just wanted to touch on a couple of things because especially to address a concern that juror 36 had raised. It's not well known, but I think it's the whole state. I know certainly the 4th Judicial District offers counseling services to any juror who has served on a criminal trial. And I've offered those services in the past, and it's a confidential, sorry. The 4th Judicial District offers counseling services to any juror who has served on any criminal case because there are all kinds of things that you see. So that is one thing that is available to jurors if you are selected to serve as a juror on this case. In addition, counsel approach, please.
Mr. Cook. Good afternoon, everybody. As I mentioned this morning, my name is Will Cook, and I represent Letecia Stauch in the blue shirt. So this is voir dire. This is not really jury selection. Probably mentioned that this was more like jury deselection. Jurors are being cut loose and kind of the survivors get to stay on the panel. So I don't get to say, I want you on the jury. We're deciding who's not going to be on the jury. So this is a deselection process, but voir dire, it's a French term. It means to tell the truth. And as Mr. Allen alluded to, you know, this is a safe space, except for everybody listening on the webinar. But it's a safe space, all right? You're not going to get in trouble if you say something I don't want to hear, the judge doesn't want to hear, or Mr. Allen or the other DAs don't want to hear. We just want to know the truth because it's important. We're deciding a lot of important things as jurors. And that's why we're given the opportunity, everybody, to ask questions of each and every one. So just starting out, and I'm not going to carry a sheet around. I'm just going to kind of point to a person and say, what's your jury number? So let me start. Juror number 4, how are you, sir?
Good. How are you?
I'm good, thank you. Thank you. Have you ever seen, I think they've done a remake, but there was an older movie called 12 Angry Men.
The original black and
The
white.
original?
Yes.
Have you seen it?
Not long time ago.
Okay, has anybody ever seen the original 12 Angry Men? And and on the front row, what's your jury? 24. When did you see it? How long ago did you see it? Okay, so you have a good memory of it. And do you remember Henry Fonda was in it? Do you remember the guy who played Patton a long time ago, George C. Scott? He was one. Okay. But you remember the premise. We sat through the jury trial and everybody was like, let's convict this guy. And then Henry Fonda, who was kind of the nice fatherly type, said, well, let's look at this. Let's look at this. Let's look at this. And eventually people started saying, yeah, I don't think I'm going to come back on my guilty vote. I'm going to go not guilty. And you remember there was one guy who maintained to the very end, he's guilty, he's guilty, he's guilty. Do you remember that? Vaguely. That actor was George C. Scott. I think he's won some Academy Awards for different things. But he was angry. Do you remember that? Okay. And eventually he came around after Henry Fonda talked to him. That was the whole premise of the movie. And he said, not guilty. Do you remember that? And this young guy was acquitted. And it turned out the jury who wanted to, the angry juror who wanted to big. He had some problems with his own kid, and the defendant was a young guy and reminded him of the kid. And do you remember that being the situation? Okay. So we want people that are fair and impartial, but the reason why Mr. Allen gets to ask questions and why I get to ask questions is our ideal juror looks different. What I think is an ideal juror as a defense attorney is very, very different than what Mr. Allen thinks is an ideal defense attorney. I want to pick Henry Fondas on my jury, and the people want to pick more along the lines of George C. Scott. Okay? That's what we want. With this process, though, generally speaking, we land somewhere more in the middle. And that's the way it's supposed to work. You want some people on a jury that have had good law enforcement experiences, bad law enforcement experiences, some that think this way, some that think that way. That is what society is like. So are you okay with this idea that we want a little bit of everything? That is a jury of your peers. It's not just all people that feel one way. It's not all people that feel the other way. But it's a nice mix. Okay. All right. Juror number 4, how do you feel about that? I mean, do you think we should have all people that are pro prosecution, or some people that, when I was a kid, I got arrested for this, got put in the juvenile home, and it was unfair. The cops were wrong. They, roughed me up. Do you think it's good to have a nice mix?
Absolutely.
Okay. Mr. 34. What do you think about that idea?
I agree with so.
Needs to be a good mix. Is there anybody here that thinks, or is there anybody here that thinks that, you know what? We don't need this long jury process, this jury selection, deselection, whatever Cook calls it. Let's just get the first 12 people up here and let's do this thing. For anybody that feels that way, or do most people, and I want to see a show of hands on this one, do most people feel that it's good to have a mix? It's good to have people from all walks of life and all experiences on this jury. Show your hand if you agree with that. Is there anybody that disagrees with that? I think I don't see any hands. Okay. In Mr. Allen's statement, he talked about Lady Justice. That she's blind, she has a sword, she has scales of justice in her hands. She's not blind, she's blindfolded, I should say. And he says, well, that represents fair and impartial. You come in as jurors, you come into this process blind. You don't know what's going on. So you're fair and impartial. You have no prejudgments. Now,
13.
13, you're number 13. Here's what my concern is. I've been looking over a whole lot of jury questionnaires, and it may not be you, but there's a lot saying, I think they know more about the case than I do. I'm the defense attorney. What they wrote, they know a lot. They were like, I've been following this since day one. This was search teams. I watch it every day, and I even watched it this morning before I came to sit on this jury panel. When I hear that and I see stuff like that written on a jury questionnaire, I think Lady Justice has had her blindfold taken off with respect to this trial. And that's a problem for me, whose only job and only duty is to work for Ms. Stauch. Can you see where
Yeah, I agree with you.
I'm going to get a little heartburn over that? How do we get around that? Or how do you get around that as a juror? You're on this, you're being told, hey, this is the way you need to think if you're a juror. You've written down, a dissertation on all the facts you know about the case.
Gotta listen to those guys.
Listen to those guys. Okay. And what can you tell me to make me, and I know it's not your job to make me feel better, but as the defense attorney, when I see that people have been following this, what can you tell me to ensure that some of this isn't going to leak over into situations?
Just gotta block all that out and go with what the witnesses say. You just can't go by what you know previously.
Okay.
You just gotta shut that out and clear your mind.
Okay.
And focus on.
All right. And did you know about the stuff that was going on with this case? A lot or a little, sometimes hear it on the news.
The news, media.
Okay. And you're number 6. How are you, sir? I'm okay. Okay for a Wednesday afternoon, but you said you know too much, and even what you heard more this afternoon hardened your position on how you feel, correct? And I think it's hard to hear all this stuff in the media for months, years and years. Like court proceedings, a judge ruled this, going to trial, probable cause. Do you think it's hard to just walk through that door and all of a sudden you're cleansed of all your memories and you don't carry anything forward with you? Do you think that's a hard sell in your mind? Why is that?
Um, Already have all those things in your mind. You know, I feel like my stance is hardened. I have opinions and bias and everything else. My knowledge of the case before this morning, and you saw in my questionnaire, was I don't know it.
Yeah,
I'd forgotten about it. It's been 3 years.
yeah.
I made the mistake of Googling it when I was sitting out in that hallway.
Mm-hmm.
That's when I realized those 3 things that I mentioned earlier in this account. Anything else that I've learned since then was, in my opinion, insane or not, the act was still committed.
And do you think if you've been following this for roughly 3 years, this is about, think if you've been following it a lot since day one up to today, do you think it's hard for you to just, there's a following this, just deprogram yourself in a matter of hours? What you juror number, was it 33? Hi, how are you? I'm good. So you're a human resource administrator, and I was looking at your questionnaire. Sometimes do that. And it said that you think you can be fair. Want to hear, both sides of the story. Is that correct?
Well, that's what I do in my job.
Okay, okay.
I just have something brought to me and then just fire somebody up.
It's important to hear both sides in a disagreement. Okay? Does everybody kind of agree with that when determining the outcome of a dispute or argument? Good to hear both sides. If there's anybody that thinks the whole, I want to hear from both sides is a bunch of baloney and, that's not the way to decide things. Raise your hand if you feel that way. I don't see any hands. So the judge, Judge Warner, he indicated to you that the burden of proof is on the prosecution. Burden of proof, the job, the duty, the responsibility, whatever you want to call it, is on them. They have to prove the charges beyond a reasonable doubt. She's presumed innocent. And if you're one of the final people to be picked to sit on this jury, the final 12, you will be determining this dispute. This dispute being whether she's guilty or innocent or whether she's insane or not. And you're going to get a jury instruction for one of the final jurors that says the defendant may or may not testify. And the fact that she does not testify, you cannot hold that against her negatively. And so what I'm trying to tell you is you may not get to hear both sides of the story. And you can't look negatively against my client who doesn't testify.
No circumstances like that. Their side of things, or maybe they just say, then what I have to do is look at
Okay. Thank you for that. And let's. Miss 36. So what do you, what do you think about that idea? You're not going to hear from both sides, or you may not get to hear from both sides. And can't hold it against me, Mr. Tellini, or Miss Stouch, most important. Well, I'm
Assuming that you're going to present another side.
well, you're not, I'm saying you, she may testify, she may not. And the fact that she doesn't testify, you can't read into it, as the judge said earlier. Hey, if I was charged with something this bad, I'd get up there and scream to the world. You know, whoever would hear me that I didn't do it. Okay. But you understand we have no burden of proof. We don't have to say anything. Okay. Judge said we could take a nap. And, give me about 6 or 7 weeks. And if you're on this jury, I think we're going to be taking afternoon naps together. But you understand my point. This is the first day you've been here. We've been in here 3 days. So, if I'm having a bad week and I've been, 7th or 8th week of trial, I may not off. You can't hold that against me. You understand? Okay. And the reason is because the burden of proof. They have it 100%. So, and juror number 37. How are you? I'm good. So on your questionnaire, you said that you're traveling March 27th through the 31st. What is that for? Spring break? Tickets bought, everything like that, flying, driving, spring break with kids and family and all that? Okay. And how old is your child? 11. And I'm not asking that for any sinister reason. So, would it be a hardship for you to miss the spring break? Okay. And why I'm asking is, we've already been picking a jury for a couple of days. We're going forward. If this isn't the right case, and this goes out for everybody. If this isn't the right case for you, or, I don't want to look at photos. I don't want to remember that. I want to take the vacation with my family. My kids are only little once. Those can be valid reasons for, getting put on a shorter trial or, not having to serve on this case. If you feel, there's no wrong answer and you're not going to get punished. But if you feel like this isn't the case for you, due to the length of it, having a family vacation already planned, due to the nature of it, now is the time to let the judge know, or the courts, or me, or Mr. Allen, whoever may be speaking, and arrangements can be made.
Yes, we start on April 3. We come back on April 3. So it's not next week. What will happen is at the end of today, you'll know whether or not you have to report back on April 3. Does that answer your question?
And you were you were in March, you say next week for spring break? Okay. Other than the vacation stuff you put on your questionnaire, is there any problems that you may have with this? What are your concerns? Okay. Okay, now I saw that juror number 38 seated next to you. You said that you're the only one working right now in your family? Was that you that put that?
I'm the only one.
Yes, juror number 38. You were the only one working? And so when it asks for hardships, you put that down. I mean, is this something you can get by? I mean, I don't want you.
And so it is something that my day job would be affected. But I do crisis at night.
Okay,
So it's call things.
okay. Okay,
Fine. Would it be hard? Yeah. I don't know if my work reimburses. But I also have private practice as well.
okay. Okay. And thank you for that. Juror number 39, how are you? Good, good. Do you have any hardships or based on what you've heard? Um, yes. Okay, here's what I don't want and the judge doesn't want in a juror. That, and Mr. Allen, we don't want a situation where 2 weeks comes by and we're first, second week of May, still have 2 or 3 weeks left. And your workplace is falling apart. You've been gone for several weeks. It's a disaster there. You're worried about money. You're worried about picking up kids. Everything's being held together by duct tape in your life. And you're thinking more about your problems and what you're missing and who's going to cover your next shift than you are listening to sworn witnesses who are here in the witness box testify. So that's what we cannot have in this room. And if you think it's going to be a problem, let us know. Like, there's no shame in that. There's no, if you can't serve for 2 months on a jury, you can't do it. And if it's because of work, if it's because you don't want to look at photos of a decomposed 11-year-old boy and autopsy photos of that, then that's fine. There's other cases. There's DUI cases to be had. There could be a slip and fall or, a case with, me rear-ending Mr. Allen in a parking act or a driving accident. There's lots of different cases that you can be on. It doesn't have to be this case, which is super high profile and super long. So what do you think? Are you the right person for this case? Well, now's the time to say it. And we kind of need you to say like, yeah, okay. And why do you say no? Okay. Okay. All right. So you're worried about the photos. You don't know how it's going to affect you, do you? Okay. And there's a lot of other places you could serve your civic duty in jury trial capacity besides being here. Okay. Is there anybody that feels the same way as juror number 39? It's like, I want to do it. I want to serve in this case, but this isn't the one. There's other places I could be, and I'm not the best juror. So I want to get my calendar up. Anybody up here?
So just can I ask a question? What day is the 3rd of April?
That's
Is that
juror number
lunch or
4.
It's Monday.
April 3 is a Monday.
Oh, okay. So, yeah, kind of.
Okay.
I have travel plans set up for the second, and third, that Sunday night into Monday.
Okay. I think you should be fine. But I'm gonna let the judge address that. He's the scheduler. I just talk. So we've got you. Anybody else in this section, the front section? Okay. And back here, raise your hands again. Were you 24, ma'am? Now, I know I saw when the photo situation was asked by Mr. Allen, I was looking at you. You got very emotional. I mean, not very, I mean, you weren't on the ground in the fetal position, but, you know, I could tell you were upset. And you're pregnant. It's looking at these photos we've discussed, and you're gonna have to see, you've got to look at them if you're on this,
Yeah,
and they're bad.
You could say that. I mean, I have a hard time like articulating, so I want to be emotional when I start.
Yeah.
But, I would say like I'm typically not an emotional person. I not want to necessarily be on this trial. That being said, like, I believe it's my civic responsibility. Personally, it would be big inconvenience to my life.
Okay, well, here's the thing. We are gonna be having people in the rest of this week, next week, doing the same thing, okay? And if you think you're gonna get squeamish, if you think there's gonna be pregnancy issues, if you think, you know what, I've got a new life growing in me, maybe I don't want to be a part of this proceeding for the next 2 months, that's fine. If you don't think you're the right person for it, you're not the right person. Here's what, as I said, we don't need heroes in here. We need jurors that are fair and impartial. Okay? And you can serve in a different capacity. You could go do a 2-day DUI trial. You could do a slip and fall. You could, as I said earlier, you could do a car accident, PI case, you know, something that's a lot shorter and something that you're not going to take home with you. And it's going to be in your data bank of memory for the rest of your life. So I think this case is just not the right case for you and you need to something else.
Yes, I would say like particularly, I don't want to do it, but if it was asked.
Okay.
That's me being.
Well, we don't pick,
Deselect.
we unpick.
So, for that reason, like I still believe like I can be a candidate per se, but I mean, me personally, I'm not.
Okay. And you do have some say in it. Like, you can say, I don't want to be on this case. And, okay. Okay, who else back here? And yes, sir, Mr. 35, I know you talked about some of the photos too, and it's seen a shooting up close and personal. What are your issues?
My issue would be photos,
Okay,
so, you know, I feel like
okay, thank you for that. And did you have your hand up? 36?
Basically, right now.
You don't have to explain yourself to me, the judge or anything. We
I heard the term Shirley would call it, press on and do it, get it done, and then. Keep transparent.
I absolutely understand. All right, thank you for that. And who else going down the list? 37? We had a special education teacher this morning, or maybe it was yesterday or Monday. I'm losing track of day. Anybody ever see Groundhog Day with Bill Murray? It's my life. And will be yours too if you get to sit on this jury. But anyways,
I already have kids to ask you, why would you care?
this is going to go through the end of the year. And if you, sometimes you have kids that maybe they're not special needs, but maybe uh, they need more out of school than some other kids. And if you're teaching that demographic, then it could be harder on them. You're more of a rock, more of a family member than a teacher. If you worry about that, that is fine. I think a good teacher and an under.
Wait. Hold on. Mr. Cook, you know better. Only one person can talk at a time. Don't talk over her. Don't interrupt her. The court reporter can only take down one person at a time. So it's important that only one person be speaking. So if the jurors would allow Mr. Cook to finish what he's saying before responding, and Mr. Cook, you need to let them answer.
She's a pretty good court reporter, though.
She is, but she's not ever going to be able to take down two people at a time. You know it, and I know it, and so does she.
All right, Judge. Thank you. Sorry. We need teachers. We need them in, underserved schools. I get that. If that's where you might be more valuable, then let's keep you there. We've got plenty of more people coming in. So you're worried, would you be worried about what was happening to your children, your kids over the next 6 to 8 weeks until the end of school? Okay. And as I said earlier, I want you focused on what's going on in here, to the exclusion of what's happening at your work and everything else. Are you okay with that?
I understand.
But I mean, you're okay with the idea that, hey, we can keep you teaching. And if that's what you're worried about, let's do it. Let's make it happen. We can do that. He's a judge. He's got a black robe. So, all right. Thank you for that. And who else would have an issue? And you are juror number 40. I think we talked earlier. Were you going to have some of the issues with the photos?
It's just a photo. I may react, I don't know. I usually avoid these things.
Okay.
I don't watch horror movies. And I tend to avoid paying attention to these kinds of things.
Okay.
But I'll do it.
Well, and I appreciate that. And it must be a concern for you if you've raised your hand several times and mentioned it, though.
The first time I,
Oh, you didn't mention it before?
because I felt like, well, it's my.
Okay. Well, you can,
Cause me to cry.
okay. What about cause you to see photos of this little 11-year-old boy who's been in a suitcase in Florida for 6 weeks under a bridge underpass? And you see that, and then you go, somebody is going to pay for this. And because I think that's a natural reaction. Somebody's going to pay. When I see something horrific, they're going to pay, and automatically they're going to make Miss Stauch pay. That's my concern as her attorney.
I don't.
Okay. Okay.
Fix most.
Okay. But you are worried about the photos having a visceral.
I'm not
Okay. And what would your reaction be?
crying.
Crying. Okay. All right. And who else raised their hand that has issues, and you are 42. Yes, sir.
43.
Okay. And this was 43. I'm sorry.
It is, right, it's 43.
Do you know if your work pays for jury duty? Some do and some don't. Okay. But it sounds like you're not in a position to have to go without pay for 6, 7, 8 weeks if you're on the final jury panel, correct? Okay. And would you be thinking about this, and would it be, if you're losing money and you're on this jury, you're going to be going like, when can this end? I'm going to get evicted. I'm going to get my, car repoed, all this other stuff. Is that going to be in your mind? Okay. Okay. You do really want to be on this jury. Okay. Now and I'm going to finish this up, but I'm going to come back and ask everybody who wants to be on this jury. We've got people that don't want to be on it and felt that this may not be the best case for them, and then maybe you want to be it, but for financial considerations. But let me finish up with those who don't think this is the right case and don't want to be on this jury. Raise hands. I know there were a few more. And juror number 55, I think you've already spoken a couple times with the photos. You're a young man, and is it still based on what you said earlier? More. Okay. Okay. Would it, we have 1 day, 2 day jury trials. Would it be a lot easier for you to handle a case like that instead of one that you're going to hear 6 or 7 weeks of testimony? Okay. March. Okay, well, I don't think this would interfere with that, but I'm running out of time. Who over here else had their hand up? Yes, sir. That is number 49. Okay. Eh, All right.
Can you speak up and repeat?
are you concerned that you can't get that fair trial because of your health concerns? Okay, thank you, sir. That's the information we want to hear, and I appreciate that.
You have about 4 minutes.
4 minutes.
Mhm.
Juror number 4, back to you, and I've just got a few minutes left. You indicated that you were gone or unavailable on April 3rd.
Right, I just said that. I have vacation plans for the 3rd, which is that Monday,
Okay,
when, if or when everybody gets called back.
okay. And so you will be here on that date? If
I
you,
will not, I am out of town on that Sunday night and get back on Monday late in the day.
so we start on Monday,
I know.
and you will have to be here if you're one of the final jurors. Is that something you can change, or is it set in stone this vacation?
Well, it's all locked on, so I don't know. Depends on how upset I want somebody to be with me.
Okay. Put it down. All right. And that,
So, yeah,
okay, so you're not available the first day of the regular trial.
like the rest of it, probably not a huge burden, but that just out of every day in the next like 3 months, it's like, that's the one.
That's the
day.
one you can't miss. Okay. Oh, juror number 2, just a couple more questions for you. Mr. Allen, he indicated he wanted everybody to come in here blindfolded, Lady Justice, and that was important, and that's the symbolism behind it. Okay. Do you understand my concern when we're supposed to have fair and impartial jurors? And, Mr. Allen spends some time talking about Lady Justice blindfolded, holding the scales of justice. And, and you put on your questionnaire, you followed news articles since the start of the case till today. And it says you have a bias based on the readings, I guess the media readings. How have you been able to go from, what you wrote on your jury questionnaire to you can or cannot be a fair and impartial juror now?
I think I have a very open mind and I understand that we have not had any testimony. Listen very well.
Okay. And with insanity, you said that you doubt, ask questions about the plea of not guilty by reason of insanity. You asked questions or you said you have doubts on insanity pleas. What does that mean?
I think that really is the key on this whole issue because it doesn't seem like there's a lot of discussion on the facts of the case other than whether the sane or, unbalanced on the day this happened.
And how do you
You'll
feel?
have, will be testimony on both sides.
And how do you?
I know a fair amount about expert testimony. I've been a PhD professor for 13 years, business owner for 15 years. But I'm pretty good at judging people and how they testify. I've hired, I've fired, and
And what do you feel about, you personally, right now, what do you feel about people that say I'm insane?
can you speak up over here?
Oh, what do you feel right now, here today, about people who claim I'm not guilty by reason of insanity? What do you think about insanity, please?
Certainly a valid plea in the court. And it's going to take expert testimony to on both sides, I think, to talk and discuss the issue.
Thank you, Mr. Cook.
Thank you.
I wanted to do a little bit of follow-up. Juror 14, I wanted to talk to you. You said that you had, sorry, you said that you, it sounded like you had some bad experiences or some bad opinions of the judicial system. Is that fair? Okay. And that's not unusual. And I'm sorry that you feel that way. It means that in some fashion, the judicial system has failed you, and that's bad. But I also have to tell you from my perspective, I think people with your viewpoints make absolutely excellent jurors. And the reason for that is they come in with, they come in skeptical, and they come in and want to make sure that everything is done the right way. So the question that I have for you is, I understand that your bias, it's really against the system. Is that fair?
Yes, in a sense, it's that it's the whole system. I've been dealing with the system for years, and I just feel that I've been betrayed, I've been lied to, my family has experienced a lot right here in this court.
Okay.
Uh, I just, like I said, I just want nothing to do with courts, the system, the whole thing. Even walking into the courtroom, into the judicial building this morning, I just hated it because I had so many bad experiences coming in here and leaving.
If you were selected to serve as a juror, one of the things that you could do is make sure that we do it right. How do you feel about that?
I just have such negativity in me, I guess, but I guess if I prayed on it, I could, overcome that and try to see things the way it should be. I'm dealing with DOC headquarters all the time, trying to get them to do things that I feel they're doing wrong. And, I guess I've got mixed feelings, I guess. Like I said, so negative, but I could
Okay.
change.
All right. And juror number 4, I just wanted to make sure you're not coming back until late in the afternoon on April 4, right? Or April 3, I'm sorry.
Yes, Your Honor.
Okay. Because at one point it sounded like you were getting in late on April 2nd, but that's not the case.
It's Monday. That's why I asked what day of the week
Right.
it was, because it's Monday afternoon.
And I think that's where I got confused thinking you were coming in on Sunday instead of Monday, but it is April 3, late in the afternoon, that you're coming back.
Right.
Right. Okay. Okay. Um, all right. You've all been subject to a number to questioning by myself, by the attorneys. And the question that I have for you now is, if you are selected as a juror in this case, are you willing and able to accept the basic principles of criminal law and render a fair and impartial verdict based solely on the evidence presented at trial and the law as I give it to you in my instructions? Is there anyone who is not willing or able to do that? Raise your hand. No response. You've been asked a lot of questions by myself and the attorneys. Is whether a specific question has been asked or not. If you are, is there any doubt that you have in the mind, or anything that you have in the back of your mind that you're saying, they didn't ask me this specifically, but I think this is something that they would want to know before selecting this jury? Anybody have any of those issues? No response. All right. Let me ask, does anybody either know myself or a member of my staff? Mr. Hercom, who do you know? Sorry. Juror number 66. Thank you. Yes, sir.
Just hearing in front of you, being involved in the association. Friends with
Okay. Anything about that you think would cause you any difficulty serving as a juror in this case?
Just want to make sure that was out there.
Okay. All right. Anyone else? Juror 14. Yes, ma'am.
Mr. Warner, I don't know you personally, but I've been in your courtrooms for proceedings in the past.
Okay.
And I don't know.
Anything about that you think would cause you any difficulty serving as a juror if you were selected to serve as a juror in this case?
Well, it shouldn't, impact that.
Okay. Okay. All right. All right. All right. With that, what we're going to do is take about a 20-minute recess. Again, don't discuss the case among yourselves. Don't discuss it with anyone else. When you come back, what will happen is I'm going to excuse some other people. And what I found is that it's easier to actually tell you who is going to be staying in the courtroom as opposed to who I'm going to be excusing at that point in time. So, but we will be left with some people who will be staying here, and I will be excusing other people. And for the people who are staying here, I'll give you further instructions and tell you what you can expect going forward. So all rise for the jury, please.
Type of engineering work do you do?
IT. I'm like a system engineer for US Space Com.
Your jacket?
Oh, yeah, it's fine. We all got it.
Just a little faster. A little bit more time here now. Oh. Not the one that we thought we might be. Yeah.
So I'm not sure. I hope they don't mute today
Well,
because
that's
yesterday they
true.
muted and we didn't
Yeah,
get to
that's
hear
That's true.
who they were dismissing. I think we're going to lose at least 5 or 6 of these people, probably upwards of 10 even, which is not good because there's only 27 left. But there are several that I'm sitting here thinking about the things they were saying, and they'll be gone. They will definitely be gone.
It's on, it's fine. All right, thank you. You may all be seated. Record should reflect the jury has left the courtroom. Ms. Stauch, would you like to take your break now, or are you okay? Okay, well, we would wait until you come back, so it's up to you. You want to do it now? Okay. So court will be in recess for about 10 minutes then. And then when we come back, we will talk about the jurors.
I'm definitely muted. So I was hoping that we were going to get to hear what they had to say. The very first day, they let us hear who the defense challenges were and who they wanted to get rid of and why, basically. They discussed it with open mic. Today and yesterday, they didn't. So they did mute. And so we will be stuck. I really hope that they remember to turn the microphone back on, though, before they start dismissing people and reading off the numbers and stuff, because yesterday they brought us back whenever they were giving the jury their information. And so we weren't sure, who was going home. We weren't sure. So I want to know how many stay, though, because it'll tell us how much closer we are to getting done. If they are able to get the jury selected, all 110 members that they want, they will have hold on. They will have will be done on like Monday. But we'll see. We'll see. We got 18 yesterday, 20 on Monday. How many are you guys thinking today is possible? Keeping in mind that there's about 20 left. And after hearing the answers, how many do you guys personally think are gonna get sent out? Because I have a feeling it's gonna be a lot. What's this guy's name? Zach DuPoint. Let me see if he's still in the courtroom. I know the jury got sent out, but did he? He's got going on. Make sure that we are following. He does not have any tweets from today. He was there yesterday. Let's see. Nothing today.
I need you.
Okay, so yeah, it doesn't look like he's there. I wonder if they have somebody else there. Let me see. How are they tweeting it out today? How did they tweet it out yesterday? Looking at the Gazette, because that is who he was there with. So, you know what the issue is? That school shooting, a lot of the reporters are reporting on that now. For those of you who didn't see that, there was 2 adults that were shot at East High School in Denver, Colorado. So I bet you a lot of the reporters ended up being pulled almost to go to something like that instead. No, nothing. Just kind of amazed that there's nobody there. How do you guys feel you would react if you were in this jury pool? Do you think that you could sit on this jury knowing that you were gonna have to look at these photos and see this crime and like even Gannon since the 6 weeks that he was under the bridge, the photos and stuff of that is what they keep telling them about. Do you think that you guys could do it? Yeah, she's been there behaving. You know what? My chat has not moved since Locomai said hi, and I just pulled up YouTube to see. I'm like, what is my microphone working? Because I can't see the chat moving at all. And look, it's working. You guys are sitting over there talking, but StreamYard for some reason stopped my chat. Yeah, that witch. KK, I know, right? Here we go. That's Letecia right there. I don't know why the comments aren't updating. I wonder if I should leave and come back and see if that works. I've never had it do that before. So weird. Hi, Dynamite. How are you? You looked because it was silent. 7 or 8 gone, if not more. You think 14, 10? Yeah. I'm thinking we're gonna lose a lot. You feel like you could do it as hard as it would be. It would be so hard you would need therapy. No way you'd be kicked out. And I'm glad to hear that the court does offer therapy to people who do have to serve as this, who do have to be up there, but I don't know. I still couldn't. I don't know. It'd be hard to say. I like to say that I couldn't just thinking about it, right? My reasoning though is more I would be too tempted to Google the case. I would be too tempted to not be partial and things like that. And that would be my issue. It would be difficult. It would be difficult in that regards. I think the evidence would bother me whenever it comes to like looking at Gannon's remains and things like that. I think that would bother me. But at the same time, I feel like it would be just like with all true crime things that I cover, you kind of compartmentalize, and that sounds horrible, but you kind of compartmentalize so that you're able to cover the cases the way that they need to be. And that sounds cold, but that's the same way that police officers and nurses and doctors and all you have to compartmentalize and do that. Yeah, Dynamite. That's absolutely. I'm so glad you're here. It's bad. You're thinking of having ice cream for your dinner. No, I don't think that's bad at all. Why does the defense attorney keep asking jurors about the motive? Because the state does not have to prove motive. And I think the defense attorney wants to put that word and that thought into their head so that they're thinking, oh man, I didn't hear a motive presented and things like that. He needs them to be found innocent, right? He needs her to be found innocent. The amount of press and things that he would get if she is found innocent is insane. This would literally make his career just like Casey Anthony's lawyer. And so that's why he's like he doesn't want any jurors left. He doesn't want anything to go wrong for him because he wanted number 1 to be able to appeal because of the fact that he was convinced they couldn't get a jury in this case. That's what he was convinced of. And he's trying to convince them that, yeah, you can't get a jury here. We can't be here. We can't watch this. We can't watch this horrible interaction and be present for all of this. Like, no, we can't. And so that's why he's like trying to convince them not to stay. Um, yeah, you've never heard of jury selection before. I think there's a lot of people who haven't, to be completely honest, that are here. If you forced yourself, you could to do this. You would need therapy for fact, but I don't think I could be biased in any fashion. She's a monster and you just can't get past that. Yeah, it's hard. I'd love to serve on her jury and you wanted Murdaugh jury too. I'm becoming a traveling jury for your next job. That's funny, Mel. Just go around and register to vote everywhere. You could probably get a double job for that. That's how they select the jurors by your voter applications and such normally. I don't know if I don't know if Colorado is different, but that's how they select our jurors here is like through your voter applications. Read about OJ's jury selection. It was fascinating. Plus, with all we know, everything about this case, most of us would be thrown out instantly. I know that KK. It disappoints me, but you're right. There is not a chance I could go in there and be like, "Oh yeah, I talked to T on Facebook." After everything happened, we talked in the comment sections. There is no way they would let me stay. How do you prove to me or to anyone else who had any type of contact with her or connection or anything like that? How do you prove to somebody who has like seen all of this that she was literally different people? And of course, he keeps reminding everybody he doesn't have to prove that she was different people. They say it, so now we have to just accept it. We have to accept the fact that Letecia Stauch has dissociative identity disorder. because that is what they are telling us. And so until they are able to prove otherwise, that is what she has. And that is extremely difficult to cope with and think of. You've been on 2 juries, but not like this one. Yes, Donna May, oh, here we go. Hold on.
Ed said he can be fair and impartial. And we have to take what is put onto these questionnaires, and this is going to be the response for probably a lot of these, in context of what they then voice when they get here into the courtroom. They don't know anything when they are filling out these questionnaires. They come in here and then they start to hear about the concepts and legal things that we will hold them to. And once he was explained those things, then he said that he could be very open-minded, said he can be fair and impartial, and also included that NGRI is valid. So I don't think that that's a valid cause to excuse him.
I agree. I think that juror number 2 has been rehabilitated sufficiently to allow him to serve on this jury. This is an issue that we ran into largely because you can't explain a lot to them about the law before they fill out the questionnaire. We're just trying to get certain opinions. And the opinion that I got from him was, well, I didn't know the law when I was filling that out. Now I understand. It does make sense to me. The challenge for causes to juror number 2 is denied. As to challenge for cause as to juror 13.
Well,
Your Honor, other than 2, we have
I said challenge for cause as to juror 13.
13, yes.
You know, it's what's the position of the parties with respect to webinar as to this part of the process? The law is that challenges for cause should be made outside the presence of the jurors. It is because the jurors are in the hallway. So potentially, what's the position of the people?
I would just ask for consistency. I'm not sure if it's been broadcast the other 2 days or not.
I believe it has. It's not. Right. Okay. Defense? What's your position?
Public.
Yeah, it seems to me if somebody was here.
Why we don't let the
Right.
jurors here, because they don't want to hear why I think they're not fair, but I think.
I agree.
I think yesterday afternoon, Your Honor, you said, well, the jurors have to be out of here, but during this portion of
Yeah.
challenges for cause, somebody could walk out
Right.
in here from the public and sit in the courtroom.
Go
So I
ahead.
think we should probably
Yeah,
do it.
I agree. Turn it on.
We're on 13.
13. Mr. Cook, what was the reason for striking 13?
This is a questionnaire situation. Mine is made up from what I've seen on news media. That was question 21. 23 is seems to be hoping for lesser charge by plea of insanity. Did make some statements that it was gonna he was gonna have some of the issues due to the charges of nature. He also put length of trial would be an issue, would make difficult but not possible. With this questionnaire and what he said, I think he was very minimally rehabilitated by Mr. Allen. Still, I think, made clear indications, verbally and written, that
Mr. Allen?
Similar to number 2, he indicated that the information that he got was from the media. We had a discussion about the media, how they don't always get the facts correct. After we had discussed all day long today, he also indicated and said specifically that he can be fair and impartial once we gave him more information about these proceedings. So again, would object to that one.
I tend to agree with the prosecution here. The challenge for cause as to juror 13 is denied. Next challenge was to juror 24.
Issue. But she was the one that was pregnant and seeing the photos. I talked to her at length about this. But, you know, I could maybe do it, try it. I think it was gonna be very awesome. Like a person that was really straining to do her civic duty, and it was a huge issue for her. She really wanted to do it, but she just body language and whatnot. 5 weeks, or almost 5 months pregnant. This was the people raised her hand different times. Feels this is the case. And also, she wrote on her questionnaire, she's out April 5th and April 4th. Your trial days. I don't know if there was any more. I don't recall any follow-up with that. But that's
I did notice that too, and I was,
one juror who's not able to be one day at jury, so this is somebody who's indicated two possible days.
Mr. Allen.
So there's I think, going to be a slew of folks that Mr. Cook is asking for cause because they said they don't want to look at the pictures. And I think juror 49, who we already, I think both have him on the list, said it the best. This evidence is going to be hard for everybody to look at. I don't like looking at these autopsy pictures. And yet 24 and all of the others also said that they don't want to, but if they're asked to do it, they will do it. And she said that specifically. When we were talking about hardship earlier, she didn't specifically bring that up, although I'm not sure if I have the correct memory, that she said she could reschedule. Is that the one that said that?
Well, I have to admit, I'm a little foggy on that as well. So I would ask her when she comes back in so I can clarify, because I had the same issue with the gentleman, juror number 4 on the April 3. And so I would need to clarify that. But I remember when I looked at this over the lunch hour that I saw that she was gone those dates. And May 4 is a Thursday, so that's not an issue. And April 5th is a Wednesday, so we'll have to clarify that, but I can talk to her about that. So aside from those issues, did you have any other record to make with respect to juror 24?
No, Judge.
I saw juror 24's body language as well. I don't mean this in a flippant way. I really don't. But I have to tell you, if we had people in here that were saying, I can see these autopsy photos and they're not going to bother me a bit, everybody would be asking for that person to be excused. I just cannot believe that that is a normal reaction. I think the normal reaction, and we've all seen really horrific stuff in the job that we do. I think the natural reaction, much like, who was it? It was juror 40 in the back that said, I think I would have an emotional reaction. And I can't say that I won't. I think that's normal. But she said that she thought she would be able to set that aside. She thought that she would be able to follow the process. She thought that she would be able to be a fair and impartial juror in this case. And based on the way she was acting about it, her body language, I saw it differently than Mr. Cook. I don't know whether it's a different vantage point or not, but I think that she can. I am going to reserve the issue about conflict for April 5, so I will ask her about that, but otherwise the challenge is denied. Next juror is juror 34. Gentleman over here on the far end.
I'm concerned with what you put on this questionnaire. Question 21 of the questionnaire. Children. So with respect to insanity. civil- There had been some rehab done by Mr. Allen. I don't think he ever discussed the insanity. Position on what he said about. But the thing. And it's clearly.
Mr. Allen?
Similar to what I've said in the others, I think if I remember correctly, in the morning session, he stood up after one of the other jurors had clarified his statements about some of the things he had put in his questionnaire, said, now that I've heard more stuff, I think I can be fair and impartial. I talked to him about those things as well, and he indicated that again. And then as it relates directly to insanity, I asked him about that, and he said he can be objective on that very point.
I recall this juror because I had a really long discussion with him about how the purpose of criminal law is behavior modification, and that a mental state has to be proven with respect to that, and why it's important for that to occur. And I believe that he understood the law. I believe that he conveyed that he could be fair and impartial in this case. The challenge as to juror number 34 is denied. Next challenge is to juror number 36.
Yes, Your Honor. This was, juror number 30.
This was the woman who had a stillborn child.
Stillborn child, and we talked to her several times. She was like, yeah, I'd like to say I could soldier through it, like, they do with the military. But she got emotional and talked about, I still remember holding this kid as this child is resulting in death. A murder of a child. So I think she was trying to put her best face forward, but I think at the end she has some personal issues that are very difficult for her.
Mr. Allen? Oh, sorry.
And beyond that, she mentioned several times about the stillborn child. She also did in her questionnaire say, I don't see that is a valid reason for a person to check for respect. Insanity question in the questionnaire. So, but yeah,
Okay.
my big concern is I think everybody wants to do their duty. And I think near the end, she finally came forward with her, most reliable statement that, yeah, I don't want to do this. I can't do it. It's just too much. And her body language, her speaking clearly did indicate that this was being from her. Not just the typical run of the mill, hey, we're all going to have problems seeing photos. Child, I get that. This was something.
Mr. Allen?
Similar to what I've said in the past on the other jurors on this particular issue, that yes, it's going to be very difficult for her, but she indicated that if she's asked to do it, that she could do it. I don't remember specifically statements that she made as it relates to question number 23 on the questionnaire, but I do remember specifically talking with her about being fair and impartial, and she indicated that she could be.
For me, I think what sways me a little bit more is, as I understood the facts and the way that she relayed the details, this was an incident that occurred probably 17 years ago. I think she said something along the lines, it stays with you, it never goes away. I can understand that. And for her, it is something that came right to mind almost immediately. That was something that I remember her mentioning it early on, and she has mentioned it more than once. And when she when we talk about different aspects of the case, including just the fact of an 11-year-old child who is dead, and we talk about the autopsy photos and stuff like that, she keeps referring back to, I had the stillborn child, I had this life. And so for her, I just think that it is too big of a hurdle to get over. So I will grant the challenge for cause as to juror 36. As to juror 37.
Judge, juror 37, I believe she was a teacher
Yes.
at the special needs, but lower income, lower areas, and she originally didn't discuss the issue with, she might photos and everything. And then my colleagues on the other side were making fun of me because I was talking about their vacation plans on March 7th. However, the bigger issue is that she indicated that she might be thinking kids that are not all the way normal kids. Or more than other kids, and they want to try to feel abandonment issues, and it would be really hard. That juror was released, especially needs teacher. I think this is the same situation with this. And as you know, Your Honor, yeah, she could probably recommend somebody in this building that it's used. Humans are pretty fair a lot, doesn't mean. It's the sub doing okay, I don't know, I'm not a teacher, but I imagine those are thoughts that go on, so. That would be my basis for 37.
All right. Mr. Allen?
Judge, I don't think any of the reasons that we just heard are good grounds to excuse her for cause. She did worry about missing work for an extended period of time, but that's going to be an inconvenience for anybody that we sit in this on this jury, so I would object.
Yeah, I tend to agree. I think she's in a little bit different position than the juror that we excused this morning. That juror, the first thing that juror described was the special needs and how it was that they were that teacher was sort of the connection to the outside world. This juror is in a little bit different position. And she didn't talk in those terms about how this would affect others. In addition, to an extent that it may affect others, that's not necessarily a reason for excusing a juror. So the challenge to juror 37 is denied. Next challenge juror was 39.
39, she was one of the individuals that in the very, very negative beyond what a normal person would experience. Negative reaction, emotion. This is a good. Social media. There she is.
Mr. Allen?
Again, the pictures issue is going to be difficult for everybody. Would apply to this juror as well, and that's not a ground for pause. As it relates to her questionnaire, she does say that she followed the case, but then she goes on in question 21 to say that yes, she can be fair and impartial. And then in question 23, to the NJRI, she says, I would need to hear the evidence for her plea. So basically she's indicating, yes, she's going to sit and listen to the evidence and not what she heard in the media, and I would object.
I agree. I don't think there's been sufficient grounds given for excusal of juror 39 for cause. The juror said that she would need to wait and see what the evidence is. And as I've said before, I think that everybody is going to have a negative reaction to the photographs. And I think someone who didn't, that actually might be a reason for excusal, depending on the circumstances. But the challenge for cause as to juror 39 is denied. As to juror 51,
Section 23, Your Honor, of the questionnaire, I do not believe that
this is juror 51.
this is 51.
Okay, go ahead.
Under court, question 23 in the jury questionnaire. I
Okay.
do not believe in the state of insanity.
Oh.
There's no reason to keep someone alive. Perfect. And then say, well, they are insane. A plea of insanity that does not bring the person back to the dead.
I recalled reading that over the lunch, Mr. Allen.
I think that is problematic. I would only point to 21, saying that he just wants the facts and the truth. So indicating that he could potentially be fair and impartial, although that statement is pretty strong.
Well, I remembered reading that. My initial reaction was that juror 51 needs to be excused. So the challenge for causes to juror 51 is granted. Challenge for causes to juror 53.
53, Your Honor. I don't know if anybody's talked to her. In her questionnaire, you put under 23, this is a person that it's a lot of information about what she had heard about Gannon before. 23, the insanity question says, where's that an excuse to try to get out of standing? 21 is, while I do find Letecia's involvement highly suspicious, evidence of clear guilt beyond reason. So I get the whole we must prove beyond a reasonable doubt. You know, right now, starting point, she's putting, you know, she's not innocent. Presume innocent, the other. It's there, he heard highly suspicious. Feels like she also did put 25, while not impossible, it would be very difficult to rent bills with only $60 compensation. So it looks like she's a retail manager and probably has some income issues. She was a person, so like, I didn't talk to her, and I don't believe Mr. Allen ever. That being said, this is the situation. Academics, open statements, you know, that.
Mr. Allen?
She was quiet. I don't remember her saying a single thing the whole day. She clearly knows some stuff about the case, but then she goes on in 21 to say, yes, she can be fair and impartial. And in fact, I think this is a really good statement. While I do find her involvement highly suspicious, evidence must prove her guilt beyond reasonable doubt. That shows a very good understanding of the law. She does have the indication in 23 to yes, but then in 24, when it's asked to expand on that, well, can you set aside that opinion and render a fair and impartial verdict based on the evidence presented at trial? And she says yes. And so I would object, saying that that's not a reasonable grounds for cause.
Yeah, I don't think there's anything, frankly, in the questionnaire that concerns me aside from perhaps the hardship. And when I asked questions regarding hardship, she didn't respond at all about anything. I will deny that challenge for cause at this point in time. Juror 73.
Your Honor, this was a questionnaire issue, probably not, you know, under questionnaire 21. Heard, read, or discussed any partial. But probably not, based on the state of the charges. And then he also mentioned that school problems, hearing loss, difficult to difficult in large groups, 2 bladder problems due to surgery, radiation treatment, state cancer, frequent trips to the restroom. So I don't think that was followed up on the medical hardships that he made. And very quickly, I think he was the gentleman that just got. That the one now?
No, the one that said that was. Oh, it
It
was.
was him, Judge.
It was him. Yeah, it was him. Yes.
You know, he did pipe up and say he changed his mind. But he wasn't very specific about what he changed his mind about. But now that I've heard some of the stuff about. Alan, I don't believe followed up with him. I didn't have time to follow statements that probably cannot. Fair and impartial based on the state of charges. And specifically. Had an unfair hardship.
All right, Mr. Allen?
He was very apologetic, actually, and I think showed reflection of the gravity of what all of these potential jurors are being asked to do, which is to sit on a really high-profile, horrific case and hear evidence. And again, when he filled out the questionnaire, I don't think he understood that based on what he said to you, that he volunteered. It wasn't even to any question. He just stood up and brought it to your attention. I also want to make sure that the record is clear that this is the juror that I know from political circles. And I asked him about that as well, and he said that he could be fair and impartial, even though he knows me through that arena. I think everything that he has said modifies his written statement and is not a good grounds for cause.
All right. All right, I am going to deny the challenge for cause as to juror number 73. I recall when he did that, and he said, you know, now that you've explained all of this, he said, I wanted to change some of the answers that I had to my questionnaire. So I will deny that.
There's one other one,
Okay.
58, I wanted to bring up as well.
58. Okay.
I don't believe anybody talked to this individual. But this individual indicated under the questionnaire they're unavailable Monday, Wednesday, Friday, and Tuesday. And then under 25, their reason and time necessary. Anyway, section 25. Yeah, I can't do that.
Take a look at that.
Hormone shots every Wednesday. So nobody talked to this person.
Okay. And he didn't raise anything about it, so I'll ask that.
Okay.
Judge, as it relates to, well, yeah, I think that's just something to follow up with.
Yeah, right, because he didn't say anything about it when I asked about hardship or anything like that. And as to juror number 14, no, I'm gonna deny the challenge. I think that I understand that she has some distrust of the system. I don't think that that necessarily disqualifies somebody. Don't get me wrong. I don't think that, I'm not saying you can't use a peremptory challenge on her, but I don't think that that necessarily disqualifies someone. I do still think that people who have a distrust of the system, I think they make good jurors. So I'm going to deny the challenge to juror 14. Did you want to make further record, Mr. Tellini?
No, I was just gonna say, I think it's a different thing at its coast system. She didn't say anything specifically about the prosecution, that she
Right.
had a bias against them or anything like that. And so I think it's a different thing. I think there's something wrong with the
Right.
system versus I think that the DA.
Well, and that's where I'm resting it on. And I also, I've seen those cases where I had one not too long ago where a potential juror said, I'm not going to believe anything that any cop ever tells me at any point in time. They're all dishonest. I mean, I didn't get that. I got that she had and has had perhaps a poor experience with the judicial system, but I'll just leave it at that.
Judge, can I just make a quick record
Go
about
ahead.
that particular juror?
14, yeah. Go
Yeah,
ahead.
14. I think it's pretty clear, if we get to the point that we use a peremptory on 14, the reasons why that might be. And I just want to make sure that we're all clear on the record that, if it comes to that, those will be the reasons. Obviously, she is, Hispanic and, want to head off any Batson challenges.
I see where you're at. Yeah, that's fine. Okay, let's go ahead and bring the jurors in. Oh. Council approach for a minute, please. So I got it.
And the camera wants to.
6:50.
He said, it is.
Okay, I wanted to follow up with a couple of things. Juror 24, we were looking at your questionnaire and you said that you were not available on April 5 and May 4. Why is that?
I have scheduled, like,
Okay, and the May 4 one is not a big issue because that's a Thursday. The April 5 would be a Wednesday, the week that we start trial. Would you be able to reschedule that?
it's possible. I absolutely have no idea.
Okay, I want you to check between now and April 3. Okay, because when you come back on April 3, you'll be one of the ones coming back on April 3, and that's going to be one of the questions I ask. Okay. Juror 58 in the gentleman in the black cover here. You said that you were unavailable on Monday, Tuesday, Wednesday, and Friday. Is that every week? And why is that? Okay. Everybody's working. Okay, what kind of work do you do? Okay. I want you to check as well, because I have had jurors in the past that Walmart did pay for jury service. So you'll be coming back on April 3 as well. So between now and then, I want you to ask your supervisors at Walmart whether or not they will continue to pay you for jury service, okay? Okay? Okay. All right. Here's what we're going to do. I'm going to point out who the jurors are that we're going to be having come back on April 3. And before anybody else is excused, you're going to see me confirm that with the attorneys to make sure that we all have the same people and the same numbers. And then if you are confirmed, remain in your seat. If you're not confirmed, you can leave because your service here is done, and you can go on about your business. So Easier if I come down and figure this out. Right, so we need for number 2 to return. For 13. 17.
That's the party cue, Judge.
No, he's closed his eyes. 019, you'll need to return as well. Return on April 3. 021. 024. 029. 033. 034. Here. 035. 037. 38. 39. 40. 43. 47. 53, 53 right here. 58. 73 and 74. Those are the people that I need to return on April 3. Agree?
Yes.
Agree. Yes. All right. So the people that I said need to stay here, stay here. Everybody else is free to leave with you.
Okay.
Okay. All right. So here's what you can expect going forward. The attorneys and I are going to continue to be in jury selection mode for about the next week. And then we will have all of you return on Monday, April 3 at 9 a.m. In a moment, Mr. Combs and Mr. Sproul are going to give you a card that will have your return time here. It also has contact information for us. So if something happens, some emergency happens between now and then, you will have contact information on how to get a hold of us and tell us what that is. Otherwise, be here on April 3. We're going to get some contact information from you. We need a phone number, an email, and then if something comes up, we can let you know. We anticipate that going through jury selection, what will occur is that by Monday, April 3, we will have 110 qualified jurors that have gone through this same scenario that you have gone through. We will have 75 of those report at 9 a.m. because we can only fit 75 in here. Then the attorneys will exercise their peremptory challenges. Those are challenges that they can exercise for any basis or no basis whatsoever. Essentially, they just can't use an illegal basis or something of that nature. So they can excuse you, and then ultimately we will end up with with 18 jurors, 12 of whom will comprise the panel. We'll have 6 alternates. We always choose alternates because the case is going so long. So in this case, that's what we've done is 1 alternate for each anticipated week of trial. So you're not yet on this jury, but anticipate that you will be. And that's important because, let me read this, read you part of this instruction. You have probably already guessed that there has been some public or media interest in this case. There could be more in the coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions I give to you. You can tell your friends and family you may be on this jury and how long you think it will go. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case, but you cannot otherwise discuss anything about this case with anyone. And you should not listen to any opinions regarding this case from anyone else. If someone asks you why, just tell them it's because I told you so. That puts the burden on me and not on you. You may still blog or communicate, just not about this case. You cannot do any blogging about your jury experience or communication with other jurors. You can still watch TV. You can still go on the internet. You can still do your shopping on Amazon. You can do all of those things, but you cannot do anything that has to do with this case. If you see a television news story or any other story come up about this case, turn the channel, turn the TV off. If you see something on the internet, just go to the next page, swipe right or left or whatever it is. You are not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia blogs, and any other website. You're not allowed to do any research of any kind about this case or this kind of case. Once this case is done, you can do all of that. You can talk to anybody you want. You can tell them anything that you want. You can tell them as little as you want or as much as you want, but you simply cannot do that while this case is pending. So when we come back on April 3, what will occur is we'll bring you all in here. I will ask you some brief questions because sometimes circumstances change. And I wanted to talk to juror 58. Make sure you talk with your employer, see if they will compensate you. Juror 43, I want you to do the same thing. I have a vague recollection, and it's really vague, so I don't know how accurate it is, that I had somebody from a car dealership before that was here that they continued to pay while on jury service, but I'm not certain. So I want you to check with your employer, okay? If they need something from me to say, yeah, right, you're going on a vacation for 6 weeks, right? If they need something from me, you will have the contact information. Contact us, let us know, and we will get something to you, okay? So, because when you come back, one of the first things that I'm going to ask, especially of you two, is did you check? What did you find out? Okay. So make sure that you do that. With that, I'm going to have Mr. Sproul and Mr. Combs give you a list so that we can get some information from you.
Yeah, thank you so much for being here. I know they muted again. It's while they are filling out those forms. They do this each day at the end here. Let me get you guys the link for Fridays. That way you guys can set your reminders and you don't forget about us since we have a day break. And I hope we can keep watching this all together. It's nice having our little chat here so that we can discuss what's going on and stuff, especially since this is really, it's like It's like Groundhog Day. They said that in the beginning. You can listen to it, and I will say that they do say slightly different things in their opening arguments. Oh, what are they saying now? Hold on. I don't want to talk over them. Nicole S., I think the only person the defense clearly wanted was the guy who said that he was anti-police. And so, of course, they got rid of him on the prosecution side. That was yesterday. They got done quick today, though. We are done before 6 today, or before 5. What is this? 4 o'clock Mountain Time. They could go all the way up until 5 Mountain Time, so I'm glad to see that they're finishing up earlier each day. But please, guys, come watch, and go set your notification bells now. That way we can make sure everyone is here, and you may as well hit the like button while you're touching the notification bell. Hey, you're finding this really valuable. You know what? They have answered a ton of really good questions while they're talking to these jurors who are asking. Like today, they asked amazing questions while Michael Allen was talking with them. And so if you guys came in late and you missed that part, I recommend going back to listen, because he explained all about the insanity defense. He explained everything, and it was really, really enlightening. I mean, they answered questions that I couldn't. See you Friday, Rexy. I'm impressed, honestly, that they got so many out of, I mean, really, they only dismissed a few out of this last little bit here. If I counted right. I was trying so hard to hear him. He was so low. That one after 13, I could not hear what number he said. So. You guys have done amazing today. I will say it's amazing how exhausting just trying to listen and process all the information is. And yet I still managed to make dinner and do the dishes today. So we're doing better. And take care of the kids, obviously. There's 21 left, Seal, if I counted properly. It has. It's been really good. You chatted more today. Monday and Tuesday, you were only able to listen because of work. I totally get it. Totally get it. No, thank you so much, Jana, for being here. WebEx is only while it's live, and so if nobody streams it, if we're not here, then there won't be a record of what happened. And I know there's other people streaming it, but listen, I want to be involved in this. I want to be involved in justice for Gannon. The only way that I can. I can't be there to serve as a juror. I can't be there to throw things at her as she goes in and out of court. Or to like hold signs up with Gannon's picture on it so that she has to see his face. Can't be there to do those things, but I can stream it so that you guys can see it. Yeah, super mom. Thank you so much to my mods too. I know it's hard to like make sure that you're here all day, and I appreciate you guys who are able to come in and out throughout the streams. It's very, very much appreciated. Although I have to say we have a pretty great chat. There's been no disagreements or arguments or anything like that. Like it's just been flowing. Nice little sleuth family. It's been really nice. This is very long pause that they're filling out this contact information. Somebody must have a long email. Thank you, CL. And thank you again for the gifted memberships earlier. And the Spudler gifted memberships today. You guys are so great. I appreciate everybody. Tomorrow there's no court, but yes, we love the lurkers too, exactly. You love our chat group, yeah. Y'all are great in the chat, exactly. I wonder if she will have moments in court like the guy in the Wisconsin, that they'll have to remove her like they did him, even though he was his own attorney. I think she'll be fine at first until it looks like that people aren't believing her, and then I think she's gonna have an issue. Like, I do not wanna see her after they read her guilty verdict and things like that. She's gonna probably not be a happy camper. Not at all. Tomorrow is Thursday, so there is no court, but I intend to probably still do a live. I don't know if it's gonna be about this. I have a couple different creators that want to collab on this. And so, either allegedly with Brittany or Joel's, let me see, another day in the car with Joel Z. May be on with me. So we will see though. I gotta check my email too, make sure nobody else has reached out. You're looking forward to the temper tantrum. That could really hurt her, I think. This is normally what they do in a trial of the jury selection. I was diminished at 6 p.m. and they still had many people left. Wow. Yeah, that was a 3-week trial. That's why they want to get so many pulled out so that on April 3, they can come back and they can select out of that. I believe he said each
Okay, so
attorney.
you all have return cards. What will happen is when you come back, you don't need to go to the jury assembly room. Report into the hallway here on the 4th floor, just like you did this morning. And then we're reshuffling the seats again, so you're not going to be sitting in the same seats that you're sitting in now, because we have 2 other groups that are ahead of you that we have jurors from too. So you will get you in here. It's just not going to be in the seats that you're in right now. If anything comes up, let us know. If anything changes for us, we will let you know. The only thing that could throw a wrench into all of this is if we don't have a sufficient number of jurors by April 3. But I think that we probably will. So with that, I'll excuse you until April 3, and we'll see you back. The people that I've talked to that said you need to check on things, please do that. So that because I'll ask you about that on April 3. With that, all rise for the jury, please. I know we're not in session tomorrow, but you guys can leave your stuff here tomorrow.
So can,
Is the courtroom not being used tomorrow?
I am, but it's primarily virtual.
Oh,
I think we've only got, 3 or 4 cases that are appearing in person, so it's up to you. And it won't take very long. So it's up to you.
I'm just gonna leave my power cord on.
That's fine.
So there's people coming in.
There will be
person
people
tomorrow.
coming in. That's true. Yeah.
All right. I'll leave my power cord. Laptops. Go.
Yeah.
I think.
You too, Hollyberry. Have a good day. Sounds like they're closing up. They're talking about leaving their power cords and stuff. I don't know
Yeah,
if he's
that's
going to say
fine.
anything else. Though he hasn't said the typical, this concludes Colorado, blah, blah, blah for the day. Oh, there they go. They just shut off the WebEx. I guess that concludes it. All right, guys, I will see you on Friday again. Make sure you guys click that link and hit the notification bell. That way you know to pop over and join us. And I will see you all then. Well, if not before, probably tomorrow. I'm sure I'll be live about something tomorrow. So love you guys. Bye.